So folks, it's a couple minutes after 9. I think we're going to get started. And well, first, I appreciate all of you coming in and meeting with us today. For those of you that that we haven't been meeting with in the last week we've had lots of hours of meeting with stakeholders and folks to try and get clarification on issues where people were confused. And today in the morning, or the first part of the meeting, I'm hoping that this doesn't actually go to 4 o'clock as it's scheduled for. But the first part of the meeting, we're going to go over the those clarification issues that that we heard from people and that we had language which we think helps clarify. We want to make sure that everyone sees that now. There are also some issues that didn't fit into that. Oh, excuse me, I left out part of it. And then after the second part of the meeting, we're going to talk about requests people have to change the policy that we've heard, and we've tried to identify those specific issues. We don't have specific language for them yet. We're still working through that. And that was my hope, that we would be able to divide everything into those two categories. But reality is messier than my hopes, and so there are some issues that we thought were clarification that had other language issues that we're still trying to work through. And so even though we've taken them out of clarification, it shouldn't be insinuated that we're not trying to move forward on those, but we just still have some language issues on those, or that they have unintended consequences that we're still trying to work through. And so we're gonna talk about some of them this afternoon, but I didn't want people who have been meeting with us to come away with the idea that somehow we don't think those are clarification. We just think that they're issues that we haven't been able to resolve associated with them. And then our plan is to, after today, to continue working on some of these language things for all of it and put out a change sheet that includes all the clarifications for the document, and a list of policy options for the board to consider at their March 5th board meeting. We will put those out at least 10 days ahead of the workshop. Is there anything else that anyone? Oh, yes. I'm not a board member, so I forget these things. If you've got a cell phone, could you put it on silent so that we don't disturb the meeting? I better do mine, yeah. And if we have a emergency signal, then we're all going to head out and go over down the stairs to Cesar Chavez Park. That's where our emergency evacuation location is. If you need help getting down the stairs, let us know. We'll find someone to help you because the elevators won't be working. And lastly, when we get to folks wanting to make comments or questions, we'll have microphones. Staff will be handing them out. We want to use the microphones because it's being webcast, and otherwise people won't be able to hear you. So my plan is to just start out and go through the clarifications. There is a document in the back of the room which is a copy of the draft procedures with these clarification language stuck in and red line and strike out in their appropriate location. What we're going to show on the screen is excerpts out of that to make it simpler. And we're just going to talk through each of those clarifying changes as we go through. If you have comments or questions, note them down. I'd like to just go through the clarifying ones first and then go back and talk about the ones where people have questions or comments. Any? All right, fabulous. Okay. So The first issue, I need a copy of this too. Sorry. It was brought to our attention that, that our inclusion of, on page 2 of wetlands that meet the current or historic definition of waters of the U.S. was causing people a lot of confusion. We meant that to just be a restatement of current law, that if it is a water of the U.S., it is a water of the state. But the way it was, where it was placed in the document seemed to indicate that it was another criteria, and that's not what we meant. So we deleted it from the criteria and just expanded the footnote to make it clear that this is a restatement of existing law and regulations. And so these two, this is these two changes are to reflect that issue. Next. So, you know, thank you. I can now see it. So we also added the word surface water of the state into the second items to make sure that we weren't capturing that there wasn't a belief that we were capturing a groundwater in that explanation. And that's what we got concerned about, is that if you excavate in a dry land, you would suddenly might have a groundwater surface, and somehow that we were including that. And so we wanted to clarify that. I'm going to go through a couple more, and then we'll stop and see if there are questions on that, because I realize that there's a lot of them, and if I go all the way through, people will forget. We also, on page 2, tried to clarify what we mean by stormwater. We meant those things that are covered under a stormwater permit, which are rainwater flow, stormwater, and authorized non-stormwater discharges that are under the MS4 permit, so that you could use these facilities that are described in here. Don't have to just be storm flow. They can be the authorized non-stormwater discharges at the same time. And then the last one on page 2, which is about the addition of facilities that are not treating stormwater or treating recycled water or treating wastewater, but might be treating surface water that has been diverted and treated for pollution reduction. We didn't want to exclude those, and so we added a new type of artificial wetland treatment of surface waters. That's what we meant, but that was to clarify it. I'm going to stop there, and I'm going to have staff make sure they've got their microphones ready. And if there's anyone has a question about those first few, what we meant or what we're trying to do, this is a point to ask those questions, and we'll move on if not. Yes.
Robert Gore from the Gualco Group. When you amended I, with all due respect to our municipal stormwater friends, you, with the compound sentence, excluded a number of people who may be recaptured in new number 4. If you feel that's the case, it's fine. Otherwise, that compound sentence is a killer. You might want to split it into 2.
What's your concern? So that
where it says, and other pollutants regulated under a municipal, I'm having the same trouble you are, Jonathan, stormwater permitting program. When it was simple, it was great. Stormwater detention, infiltration, or treatment, done. But when you add the MS MS4 qualification, it by definition eliminates everybody else. I understand their quest for certainty, and I represent the city of Fresno, but clarity would be good. That's all.
So if I can, Bob, I think, just so everybody else can follow, I think what you're pointing out is that other types of stormwater, say industrial stormwater, construction stormwater, by this change would be not covered. So wetlands associated with treatment or detention of those types of stormwater end up being excluded with this change, if I understand correctly?
That's correct. Thank you. I was trying to be nuanced, and that was a mistake. But Phil, are they not covered under new subsection IV?
I think that's a perfect example of an unintended consequence. There would not be, IV.
It says treatment of surface waters.
Yeah, no, we intend surface waters to mean essentially water that's in a channel that's then removed for treatment, maybe removal of nitrates. So I think it's a really good point. I appreciate you raising it. That was not our intent, was to...
Putting our industrial friends back in would be good. Thanks.
And this is exactly why we're having this discussion, because it's really easy when we're trying to do these things to get lost in what we're doing, and so we want to have that. So we've got that noted down. We'll figure out. It wasn't our intent to exclude treatment for construction or industrial. It just wasn't brought up, and we didn't think of it. All right. If there aren't any others on those first few, I will go on to the next one. So this change is meant to address the concern of renewals of existing orders that don't change the project, but they're renewing it either because of extension of time or a minor modification that isn't requiring a whole new analysis and application. We did not intend to do that, and so we put in some clarifying language to address those concerns and allow folks to move forward with a project where they have to extend the time or have a minor change. Is there any other nuance? You're looking a little. Okay.
All right, I'll take this one. Yeah, so the next one, as we were looking at other issues, we realized that on line 113, where we had used the word could result in impacts, that's actually a different phraseology than we had managed to use in all of the surrounding sections. So just, it's a parallel issue. At some point in the past, we had impacts in a lot of places, and we changed all of those to discharges of dredged or filled material. This was one that we missed. So this is really just trying to make sure that it's consistent with the text around it.
Okay, so I'm going to do the next one, and then we'll stop again and see. It was pointed out to us that that there's at least one instance where there is a prohibition already in a basin plan which requires, before a permit can be issued for dredged and filled material, that this analysis be conducted. This happens to be Lake Tahoe. They have a prohibition on discharge unless you can show that you've done everything to avoid and mitigate. And so the blanket statement that we had needed to be qualified so that a prohibition of discharge isn't ignored in the base plan. Is that the best way to say it?
Yeah, sure.
So this is what we proposed. Most folks have not seen this, and so, but that's the way we proposed to address it. I'm going to stop there and see if those. Oh, okay.
And then you'll see that there's actually a second change on that page. The first change is correcting the cross-reference to section 4A1H. The next one is adding the words "and as a means to comply with." And that's just essentially a more precise recognition of the fact that section 230.10A does not actually include in itself a specific alternatives analysis requirement. So it's related certainly to 230.10A. This is just a more precise way of explaining that this is how you would comply with that requirement to look at alternatives. Oh, maybe we do.
Thank you, because it's changing all the time, and we're trying to keep up. I appreciate that, Dee Dee. As they're looking at that, on those three issues, are there anyone that had a question or unintended consequence that we didn't see? Because that's what we're trying to get here. All right. So next one. It was pointed out to us that that the approach that we used for identifying projects that that inherently couldn't be changed, location couldn't be changed, we had put that in tier 2 as a but in tier 2 there is an on-site alternatives requirement, and we wanted to clarify that what we were talking about here is alternatives to the operation and maintenance for the facility. I will say at this point that there is another discussion that we will be having about, does it make more sense to change those and add them to tier 1, or to move the tier 1 things up there? That is one that we are still working our way through and considering, and but we do believe this is a clarification. It may not be the best solution to the problem, and so that's this is one of those instances where we think we can get by with this, but we've had a lot of discussion, and we still want to look at is there a different way to do it, and give the board discussions about changing that tier structure so that we can do that. And then the next one, I'll do the next couple, and I think that would make a sense for another. So the yes. Yes, we will do that. We tried to put it on the bottom of the slides, the line number and the page number. But as you're looking at what we're doing, if we got it wrong, because I'll tell you, we've been working pretty fast and furious, and we might have got a page or a line number wrong. And if it doesn't match up and you see it in J, I can't follow it, raise your hand and we'll figure it out. That's all right. So the next, this addition to page 9 is to recognize that in some instances the restoration is through essentially letting it restore or helping it and letting it restore, but it's not the stretch that was impact for temporary impacts gets restored there, and there's not that impact isn't required to do compensatory mitigation somewhere else, or and this was supposed to recognize that. Yeah. You're giving me a look.
Well, so actually, I think depending on which version you have, this may be a situation where you got the wrong page number. That's right. Thank you. I should explain that. So when we do have a line number and a page number, it's not referring to the version that you may be able to get a copy of. It's actually the version from January 3rd that was distributed to the public. That's what the references are to. So just a little bit more on the purpose of this addition here is we were asked to recognize that, first of all, in some cases, if there are temporary impacts, usually as a result of the construction of the project, that our requirement sort of assumes that the restoration of those temporary impacts will be actively managed. And so we were asked to recognize that in some cases, we can let nature take care of those temporary impacts. And so we are recognizing it here, and we're just saying that if that's what your plan is to allow natural restoration to restore the site, then you do need to still include some discussion of that in your restoration plan.
All right, and we're going to talk a little bit about the mitigation ratio issue. So what we intended was that the mitigation ratio would be measured as area or length, so it would be mitigation for the impacts by area or length. And we wanted to make it clear that that the point of that is to improve the function, and not only to improve the ratio, but to improve the function, and that that a higher mitigation ratio may be necessary to do that. And so we added that as a clarification. It's not necessarily a requirement, but I should say that that our experience is that most mitigation ratios are greater than 1-to-1 for compensation, and I didn't want to mislead people that it was just a 1-to-1 mitigation ratio in all instances. I'm going to stop there, and we're going to, yeah, sure.
Sorry, could we get a mic over, please? Thank you.
I feel like I'm on Oprah.
Oh, that would be nice.
Yeah. So just a few clarifications on the mitigation ratio. This is Clark Morrison with Cox Castle. A few items we had discussed. One is the coalition was hoping for language and made it clear that the 1-to-1 could be met by preservation, enhancement, et cetera. And because right now I don't think it's clear. We were also hoping for language indicating that temporary impacts would be self-mitigating relative to the 1-to-1 ratio, recognizing that temporal loss or other things might need to be used to bring it up to full functional replacement. And then one clarification of the new language relative to area or length. Is it true that we can use area or length with respect to both wetlands and stream losses? That is, can stream losses be mitigated in acreage rather than lineal feet? So those would be our requests for clarification.
Sure. So let's go through the three issues. It is our intent that, and I thought we had it in there from the January 3rd draft, that it includes enhancement and restoration, and maybe I'm got confused, but.
It's not explicit.
Mitigation is defined in the supplementary guidelines, and it includes restoration, rehabilitation, enhancement, establishment, and a number of other options
Okay.
there.
So we may need to add that just as belts and suspenders. I get that. So that's the way that.
That will go back in, okay.
Yeah. Well,
It's in there now, it's just in the supplementary dredger fill procedures. We can add, as John said, belt and suspenders to make a more clear reference to that portion.
Yeah, we'd like to see that in the policy, I think.
And the second issue was about that self-restoration temporary impacts could be done by self-implemented, whatever the term is.
Maybe friendly amendment here that temporary impacts, because they're temporary and they go away, the temporary impacts are essentially self-mitigating relative to the one-to-one standard, not necessarily relative to full functional replacement. So we had talked a little bit about that, and I think Phil just.
We didn't actually have any language, so we didn't propose any language here, but I think you can get there pretty easily with the notion that mitigation is discretionary in the first place, but I think I understand the point. You'd like it to be explicit that the acreage and the length doesn't necessarily have to apply to the temporary mitigation for temporary impacts.
Yes.
Okay, great. That clarifies that. And I don't know the answer to the last one, that if you have a wetland and you wanted to replace it by the length of the shoreline, I guess, or if you had a stream and you wanted to do the mitigation based on the area of the stream, we're just going to have to think about that. I don't have an answer for that question. It's not one that we had considered. My understanding of it was you would use an area for an area feature and you'd use length for a length feature, and that's the way we proposed it. We'll have to think about if it makes sense to allow some other approach. Yeah, should you, oh, there it is.
Just, Clark, could you talk a little, hi, Dee Dee over here. You can't see me. Could you talk a little bit about that last issue on linear feet or acreage, just so there's maybe a little more discussion on it? I'm wanting to understand where we leave off on that point.
Raise your hand, Clark. They don't know who you are.
Thank you. What we've found in practice is that stream mitigation is extremely difficult to find and identify in most situations. It's one of the biggest challenges we have. And the San Francisco Regional Board has been, we've been working with the San Francisco Board on that for some time. So we may often have situations where you simply practically cannot find one-to-one mitigation in terms of lineal feet of stream. Sometimes you just can't find it, which means the project would die because it couldn't meet that one-to-one standard. And so there has been hope expressed that that you could also choose to mitigate streams by acreage. Now, that may be less satisfactory from a functional replacement standpoint. You still have to meet that standard. But for one-to-one only, we'd like to see streams able to be mitigated by acreage and not just lineal feet, because lineal feet are really hard to do.
So, Clark, how much would the explicit recognition that the one-to-one can be satisfied by enhancement take care of the issue? We understand it's very hard to replace stream length, but is enhancement?
It certainly helps. Preservation also, it helps in that respect. But sometimes you just can't find it at all, in terms of, full replacement. So it makes it easier, but it doesn't necessarily solve the problem.
Hello? Yeah, just because I want to make sure we're understanding the terms. When you say acreage, I think what you mean is acreage of a different type of feature. For example, acreage of wetlands being used to mitigate a stream impact. Is that correct?
That might be one scenario.
Because that really is more of a type conversion issue as opposed to an issue of how do you measure the impact. And that is accounted for in our supplementary procedures.
Out of kind would certainly not meet if you were one-to-one in terms of the area, it wouldn't meet full functional replacement in most circumstances, but the regional board would add to the require mitigation to be added to the package to bring it up to functional replacement.
typically out-of-kind mitigation that does have a higher mitigation ratio.
Yeah, we expect that. But it would be helpful. We all know that we're subject to full functional replacement, period. And I think the way this is written, most instances, particularly if you're using preservation or enhancement, you're going to come in at under full functional replacement. You're going to have to supplement your mitigation package. So we would propose that we allow acreage to be used for stream features, pardon me, even if it's out of kind, where it's infeasible to find stream features to fully mitigate it one-to-one in terms of length. So we'd like to see some flexibility there. Not necessarily an absolute, but where it can be demonstrated that a full-length replacement of a stream feature is impractical for some reason.
So it sounds to me like what I'm hearing, and we'll continue to confer with staff, is that is already contemplated in the supplemental guidelines, so we can look at how best to bring it into the procedures so that we're clear. We're not trying to make it unclear, and so I appreciate the comment.
Thank you.
Good morning. Thanks for the clarifications and appreciate the work staff's doing to try to clarify things and also address some of the concerns. I had a question about on page 7, the language inserted on, I think it's lines 210 through 212. For routine operation and maintenance of existing facilities, analysis of on-site alternatives is limited to operation. Okay, I've lost connectivity for a second. Is limited to operation and maintenance alternatives to the facility. We had some good conversations about this. I think as the language you used to replace, there's a couple issues. Yeah.
I don't mean to cut you off, and we can talk some more about it, but I just wanted to say that I tried to highlight that this is an area that we still need to work through. This was one way to address it, and I understand that it didn't, there was still concern that it might be better to move it to tier 1 or move that tier 1 thing up to tier 2.
Yeah.
And we're trying to figure out ways to write that language, and we think that there are options there that we need to discuss.
We provided some language to staff late last night that I think is consistent with our prior discussions. Hopefully you'll consider it.
We will definitely consider it. We have not had a chance to look at stuff we got last night.
It
I apologize.
was late. So. But we can provide that if it'd be helpful.
Is there any magic to the use of the word routine in that last slide? What was your thinking on that?
The answer is yes. Routine was added intentionally in the idea, and just a general dictionary definition. So these are things that are can be anticipated and planned in advance. The idea here wasn't to include as routine operation and maintenance things that may be, and we had this conversation, I think, with the stakeholders, but that may be very much out of character. It may be things that weren't anticipated, and so therefore, when the permit was first issued, there really wasn't any way to anticipate that this particular type of activity, which maybe could be characterized as operation and maintenance, was part of the real project. So again, the idea is to cabinet it into things that were anticipatable and planned for.
This is sort of a general comment, so it's perhaps for later, but one question would be where you have an emergency. Again, let's take an example of a debris basin. You have an emergency clean out of a debris basin. Now that debris basin needs to be cleaned out only to its original capacity, so it's not being expanded or reshaped. In that sense, it's routine, but it's not a routine act because we had a fire or something and it has to be cleaned out. So any thoughts on that?
Yeah, I would say that this would not include emergency actions under this particular provision. We can talk about the ways that the water boards have historically provided very streamlined permitting for emergency actions. But I think you raised a valid point. This would not include things that could be characterized as operation and maintenance, but in fact are unanticipated because they're a response to some form of an emergency.
Okay, thank you. Oh, yeah.
Just, I would say the use of the word anticipated rather than routine might be a better choice. Just consider that.
All right, so we got a number of comments on how we deal with existing habitat conservation plans or natural community conservation plans, and we're going to go through a few issues on that, but the first one is on the, so don't think that this is the only one, is the reason I was prefacing that. The first one is on a definition of a watershed plan. And so we did not include municipal stormwater or watershed management plans in that description. And so what we did is try and make it clear that these were examples of what would be a watershed plan, and that these that it would also include these other plans if they met the specifications. So I think that, unless there's, yeah, so, all right. Yeah.
One clarifying question, not on the definition itself, but the means by which the watershed plan is used. We discussed earlier in the procedures, there's a provision requiring the regional water boards to actually approve the plan itself. And it's not clear to me that that happens in all instances with respect to HCPs. For example, the Central Valley Board, I think, and I'm a little bit uninformed on this, but I think they might approve a cert for regional general permit, but I'm not sure they're necessarily set up to actually approve the entire plan.
That's correct. And so you'll see that actually it's the language that's on the screen here. We're not intending by this definition to say that the regional boards or the state board would be in the position of actually approving, say, HCPs and the CCPs. It's a subtle difference, but what it really says is that we can approve the use of that plan for this purpose. And so it wouldn't require all HCPs to be approved by the water board. Rather, what it would require is that if an applicant wants to use an HCP as a watershed plan under these procedures, then they would have to ask the permitting authority to look at the plan, decide that it meets the requirements, and then it can be approved for use as a watershed plan under these procedures.
I appreciate that. I think there's another provision outside of the definition in the procedures themselves that says the permitting authority has to approve the plan. It's not in the definition, it's elsewhere, and I can find it for you, but I appreciate your intent, but I think there may be one conforming change that needs to be made, and I can look for that.
And yes, if there is, please let us know. And now we have another comment, and then we'll go.
Clark sort of took what I was going to ask. The other question is, when you say it meets the criteria above, that's in watershed plan, you mean the preceding language that talks about what a watershed plan does? Is that in the definition of watershed plan?
Yes. So what we mean to refer to is right there within the same definition of watershed plan, that it has to have been developed in consultation with stakeholders. It's for aquatic resource restoration, et cetera.
Yeah, it's
addresses,
the preceding language.
the exact same language that's just 5 to 6 lines above.
And then just to follow also on what Clark was saying, all of our existing HCPs and NCCPs are approved already. So, except for one remaining one. So the question is not to have to go back to the Department of Fish and Wildlife. It's, in San Diego, we asked Dave Gibson, does this meet your criteria for satisfying what a watershed plan is?
Precisely. That's right.
And is there what if Dave says, kind of? How do we work with kind of?
So if you have a plan and it doesn't quite fit exactly what our definition is, there's no reason why you couldn't supplement it just for the purposes of making it actually whole for a watershed plan without going back to the other agencies, unless it implicates the other agencies' concerns with respect to what they've already approved.
So my response to that would be, okay, but because we have approved watershed management plans as part of our MS4 process, those two together should more than cover the regulatory needs associated.
I think I'll just restate it. I think your point was that if you have a stormwater watershed management plan and a habitat conservation plan, that the combination of those two plans should meet our needs for a watershed plan.
We hope so.
Yeah, so I mean, definitely I would say that the watershed management programs or plans under the municipal stormwater permit are a slightly different creature, at least as required currently by the stormwater permits. They don't necessarily touch on all of these factors. And I would presume that in many cases, if you combined it with an existing habitat conservation plan, you probably would have all of these match up to all these features here that are in the definition. The point is that the permitting authority would need to look to confirm that in fact it matches up.
And then the approval language that Clark cited a second ago, did you find where that was?
Yes, I did.
Oh. Wait.
Yeah, Phil, there are two locations where it refers to the watershed plan having to be approved by the agency. The first is on page 6 of the red line, ruminant 3. This is in the alternatives analysis section. And then there's another reference, a similar reference on page 11 under the heading Strategy 1, describing watershed plans.
Thanks, Clark. I think I believe the change will be pretty simple, essentially importing that same notion that it's approved for use.
Right. Yeah. You know, one thing maybe to get at this question about existing HCPs, and this is perhaps a policy question, but I think it would be helpful if there were language at the end following if they meet the specific requirements stated above, or otherwise make the permitting authority happy that it's adequate for use for purposes of the procedures. So that if an existing HCP doesn't strictly meet those criteria, but it's still good enough for the regional board to base mitigation decisions on, that they should have the discretion to be able to do that. And I'm worried about existing HCPs, Contra Costa, Santa Clara, San Diego, and Southern California. I believe the two ongoing ones in Sacramento are working to meet these criteria, but there are a lot of existing ones that if the rules change within those HCPs, it could be problematic. So perhaps some discretion to the regional boards to look at them and use them if they are adequate in one form or another, even if they don't strictly comply with those criteria.
I would agree with you that we're going to have to look into the ramifications of that before we can say one way or the other. We did try and capture some of those issues that you'll see in a minute on the ecological restoration project issues, but I'm not sure that it covers what you were saying. So I'm
Right. Thank you.
yeah.
Yeah, Bruce Barnett, Barnett Environmental. I guess I'm trying to look at this from the forests and not the trees. I know you guys are deep in the weeds on this, been working on this for a long time. I have to, of course, translate this out for clients in jurisdictions And I have jurisdictions, for example, South Sac HCP, everybody's just approved it. We now have to go through these. Your language here says you may approve the use of these plans. Well, I have jurisdictions that will only permit through these plans. So if you don't approve the use of the plans that these jurisdictions will only allow permitting through these plans, we have a problem. Because then, not only do we have to satisfy HCP and CCP requirements, but we also then have a separate set of requirements that are not, that these permitting agencies and jurisdictions haven't been exposed to before. So this new policy that you guys are proposing is now on top of the HCPs or NCCPs because you may or may not approve the use of those plans for your purposes.
So maybe a little bit of a misunderstanding. Plans that qualify as watershed plans actually get relief from some of the procedures, and it's spelled out which procedures you can use a watershed plan to get relief. So big picture, nobody needs to have a watershed plan or an HCP that is approved for use as a watershed plan. They can still proceed with the normal permitting requirements. If, however, the water board approves the use of an existing HCP or a new HCP as a watershed plan, then what comes with that approval for use is the regulatory relief that's built into the procedures. Now, I believe South Sacramento, in that particular case, I believe, and tell me if I'm wrong, that the regional board plans on issuing a regional general permit to authorize the discharges that would be associated with that HCP. At least that's what their attorney told me yesterday. If that's the case, then actually Chapter 4, or Section 4, wouldn't apply in any case because it's for individual permits, and this would be a general permit. So there's kind of a couple different ways you might get to where you're looking for. And I'll just say just generally, to the extent that any entities have an HCP that's approved by the wildlife agencies, it may or may not satisfy the water board requirements. I mean, ideally, they would be brought into the process for development and they could sign off along the way. But we have seen some in the past where they were approved for wildlife purposes, but they didn't necessarily meet all of the obligations that the water boards had. So sort of a plug for including the water boards in the process if you want to get sort of pre-approval of the activities contemplated by the HCP.
Okay, and I mean, another issue is some of the plans up here, and I don't mean Southern California, but like the South Sac HCP or the Yolo County HCP, they haven't even been implemented yet. There's no infrastructure implementing these HCPs yet. Now, they've all been approved by their jurisdictions, constituent jurisdictions, but they have not yet been implemented. So I guess the question is, how does that fit in? Maybe I'm asking this in the wrong venue. Maybe this should be in a much higher level discussion. I'm just confused by your language here because there's HCPs in all sorts of stages of development, and the approval or the may approve, and that was what kicked off my question. How do we know whether you're going to approve it or not? Because then we have to kick in a whole new set of requirements and regulations and processes and procedures.
So I think we need to, I'm going to try and restate what you said, which is that the watershed plan was put in to recognize that there are these planning activities that are going on a watershed scale, and that in and of itself might satisfy some of the issues related to dredge and fill activities. It's not a requirement. And so if you've got one of those that satisfy it, this is a way to say, look, we've already done the planning for this. We don't need to redo it in your procedures. And so I don't want to get people hung up on, oh, we've got to go out and we got to change our HCP or we got to do this to meet these procedures. No, but if you've got these things already done, we don't want you to do them again project by project if you've already done them on a watershed scale. Any other on this before we? Yeah.
Wondering how are we contemplating that approval happening, and how was that documented? Wondering how you might have HCP or a combination of HCP and other documents. Is this staff to staff kind of approval for one-time use, or are we looking at, once we're going to have a formalized approval that will then be documented for use throughout time, throughout maybe different regions, say an HCP spans different regions? Yeah, are we looking at this permit to permit to permit, or is this going to be like a one-time approval for a plan?
Yeah, good question, Sean. So we're trying to be fairly open here. I mean, my expectation, frankly, is once a particular document or combination of documents is approved for use as a watershed plan, it's for that document or set of documents and any projects that would fit within it. In terms of the question about who gets to approve those documents for the use as a watershed plan, the definition of permitting authority essentially leaves it to the particular regional board. The regional boards are authorized to delegate their approval authority of many things to their executive officer, or in some cases even further down. So it would depend on where that authority has been delegated. And certainly in some cases, even if the executive officer does have the authority, if it's a really significant item, they may take it to the board. They may choose to, just to get more public input, but they might also just delegate it to their executive staff. Does that answer your question? And I should say, and we're intentionally leaving it to the water boards to decide at what level the approval occurs.
So this can happen, it sounds like, at multiple levels.
Yeah, I would say probably, or maybe even definitely not at the line level staff, but either at the board itself or the executive officer or his or her designee.
Are we looking at some form of like a clearinghouse for documentation of these approvals? Like, will there be a place to go to look to see if a plan is approved, not approved?
We don't have any immediate plans for that. That's not something that somebody's asked us for. We do have a number of tools that are currently in place and under development. One of those is the Eco Atlas system, where you could capture that information right now. I think it's an interesting idea. I'd love to talk to you about it separately.
Thank you.
Okay. Oh, is there another? No worries. We're just trying to make sure we capture everything. All right, so this issue, this is in our section about when an alternatives analysis is required. Is that correct? And so we got a lot of concern about what does habitat mean, and how do we address that. I am not going to represent to you that we think we've got this 100% right on this one, but what we're trying to convey is that it's habitat in waters of the state and not habitat associated with a project. And so that's why we added those words, because there was concern that if a project that has a potentially an impact to a species that is not associated with the dredge or fill activities, we don't have that authority except in the dredge or fill activity. Is that the right way to say it? We don't have the concern. We're not yeah. So, all right. Next. All right. So, this is essentially a moving it around change to try and make it clearer what we were proposing. I'm not sure it helps, but this is what we think helps to clarify that that if the Army Corps doesn't apply the rebuttable presumption, then we won't apply it either. Is there any other nuance that I should say on that, Bill?
Sure. So just to be crystal clear, this would apply only where the discharge of dredged or fill material is to a water of the United States, because that's where there's a potential for the Corps to not apply the rebuttable presumption, but in the absence of this section, for the water boards to apply the rebuttable presumption. So we're really, this language is really just both the original version, as Jonathan said, the moving the words a bit version that you see here. These really are just focused on avoiding the possibility that you would have two agencies looking at a project, both the Corps and the water boards, and that one agency would apply the rebuttable presumption and the other agency would not, because that could lead then to the two agencies coming up with different ideas as to what the least environmentally damaging project alternative is. So just to be crystal clear, this would not apply if the discharge of dredged or fill material is to non-federal waters of the state.
And we know that isn't a request, and we will be talking about that. We recognize that there are a number of people that would like us to apply, not apply the rebuttable presumption to state waters only. And so that's one of the ones we'll be talking about under proposed changes for the board to consider. Yes, Clark. And
thank you. Two clarifications. One is, I assume the phrase any non-vegetated water of the U.S., that's shorthand for what we call two parameter wetlands and what you call modified three parameter. That's what you're getting at there?
It's for the part of the wetland definition that says lacks vegetation.
Okay.
Yes.
What about a situation in which you have a project that will affect both federal and state waters? Maybe they're part of the same water body and one is partly federal and partly state. In that circumstance, as I read the language, you would still have to do a lead analysis even though a large part of the activity is federal. It seems to me where you have a project involving both state and federal features that become implicated by the rebuttable presumption, that you could have conflicts there in mixed jurisdictional situation. Obviously, from a policy perspective, it would be our preference that the rebuttable presumption not apply to any is, whether they're state or federal in nature. But just in terms of mixed situations, I think there's a clarification needed there, because I think it could cause unintended consequences.
Yeah, we'll definitely take another look at something we've certainly discussed internally. I mean, the way I read the language, I think is probably consistent with what you're suggesting, Clark, which is the discharges would have to all be to waters of the U.S. And we understand that that may not be exactly the result that everybody likes. So we'll take another look at it.
all right. So I'm wondering if we could go to the next one, because I think it makes more sense to talk about this one first. So what these two are intended to do is to address the issue where we have a ERIP project, and there are or potential regulatory relief associated with enhancement projects, because we want to make sure that we incentivize those. And so this one, if I'm reading it, oh, well, maybe I did it wrong. Okay, yeah, so the first is that if an ERIP has been approved by a state or federal agency, the enhancement plan is going to be, will satisfy. And if it isn't approved by one of those state or federal agencies, it may well satisfy, we just need to take a look at it. So we wanted it to bifurcate those two instances because it was confusing in the language we had before on would the may apply to ones that had already gone through the HCP process. And
it sort of relies on the definition of EREPs. Yeah, so this slide assumes that you have some familiarity with the definition on page 15 of ecological restoration and enhancement projects. We talk about those as projects that are undertaken by various types of agencies. And so we're essentially saying that if it's a project that's between the landowner and a resource agency, a federal or state resource agency, or a local agency that has a primary function of managing land or water for wetland habitat purposes, then in those situations, we will presume that it meets the requirements, the project meets the requirements that we spelled out for an ecological restoration enhancement project. On the other hand, if it's a project that is undertaken by a landowner and a non-governmental organization or a state or federal agency that has some natural resource management tasks in their statute, then we'll just take a look at it, like Jonathan said, to make sure that it actually meets the requirements for an ecological restoration enhancement project and that the assessment plan itself is actually sufficient, if that makes sense. So we're differentiating between which agencies are working with the landowner, and for some of them, we will presume that whatever they said is sufficient for an assessment plan is going to work for us. Others will have to take a look at it.
And so just to be clear, what we had before is that they all may apply. And so we were just correcting or rearranging it so that it was clear that if they've got an approved by a state or federal restoration or a local agency with primary function, that it would be. And so it's a little bit more specific on that. We can go back to the X one, which is just part of that, as far as I can tell. It just adds on to that discussion. It's in another place.
It essentially says it may satisfy the requirement for a final restoration plan.
Right. Yeah. So
This is what was added to the restoration plan for temporary impacts.
Jonathan, Jeff Volberg with California Waterfowl Association and the Central Valley Joint Venture. We're comfortable with this language. It reflects what the discussion was last week, and so we are comfortable with this. Where we're a little concerned is with the temporary impacts analysis, and could use a little clarification on that. The type of, usually an EREP project, the intent is to come out with either a restored or enhanced habitat, wetland habitat. If there are temporary impacts associated with that and we have to prepare a restoration plan, it means that kind of swallows the rule and creates an additional regulatory burden. Ultimately, the outcome of any EREP project is to have an enhanced wetland habitat, and that would, of course, involve correcting any temporary impacts that are involved. But if we have to go through additional assessment
of the temporary impacts, again, that defeats the purpose of trying to streamline the EREP projects.
So I think I understand the concern. The language here on 282, and by the way, I need to correct something I said earlier. The line and page numbers, staff was able to quickly scramble and make them match up with the red line version that they passed out. So thank you for doing that. They don't match up with the January 3rd version. So I was wrong about that. If I understand the concern with this particular language on lines 281 to 284, I think what we're trying to say is we sort of assume generally that that ecological restoration enhancement projects will have a restoration plan, and that part of that restoration plan will restore the temporary impacts, generally construction-related impacts, to pre-project conditions. We're just trying to recognize that in most cases that would be the case, and you wouldn't have to do a separate plan. We couldn't say for sure that in all cases it would the restoration plan would accomplish that objective. Does that make sense? We're not prejudging things we haven't read.
The temporary impacts would be necessarily corrected in the process of achieving the outcome that we're trying to achieve. So we're a little concerned that if in a situation where there will necessarily be temporary impacts in the process of achieving that outcome. So if we have to stop and separately analyze and assess those temporary impacts that will occur in the process of achieving the final outcome, it puts us in a position of again having that regulatory burden, which will be resolved in the.
Yeah, that's not our intent at all. Our intent is that that to try and recognize that when you have one of these plans, they, by their nature, they would address the temporary impacts, and we didn't want it. Without that, it's not clear that that we think that those might well take care of it, and that's what we were trying to accomplish. We can still consider how to best structure that. It wasn't meant to add a new burden. It was meant to say, oh, these restoration plans would, in most cases, do that, and you could use that to deal with the temporary impacts. And we put a may because there could be an instance where it doesn't. And so, but if there is a better way to say it, we're open to it. We're just trying to acknowledge that issue.
What will we have to do to comment on that? I mean, what's the time frame? And
so the best thing to do is think about it and give my staff a call or an email so we can talk through the issue.
Thank you.
Oh, yeah.
Mary Lynn Coffey with Nossaman. On this EREP definition, I'm wondering if the term landowner is intended to encompass local agencies who may not own a fee or own the land. They may be doing one of these EREP projects on an easement area or something of that nature.
So we actually did not anticipate that it would be somebody other than the owner of the parcel, the fee owner. If you tell us that these often can be undertaken by somebody other than the fee owner, I think we would be definitely open to expanding it.
Okay, yeah, we submitted some comments on that on January 21st, or some red lines on that, and the issue is just that often when a local water agency or flood control agency does this project, it does it on an easement, and it's not necessarily a landowner.
Okay, yeah, I think we'd be very open to expanding the definition or expanding it beyond just the landowner.
And I just wanted to comment. I know that folks, we got probably 500 pages of red line comments, and we tried to go through all of them when we had our individual stakeholder meetings and try and address all the issues. I totally admit that we might have missed some, and so we're not we didn't make a judgment on that, we just missed it.
And I was asked to give a site, so that would be in the section 5, Roman 5 definitions. Ecological restoration and enhancement project definition, that starts on line 514 of last night's red line, but not the one that was in the back of the room.
So I'm going to turn to my legal counsel because I don't remember discussing this, and so I'm not sure what it's
Sure.
The edit is just whenever we mention meets the terms and conditions of a nationwide permit, to make it explicit that that would include any time a core district implemented regional terms that are corresponding to the nationwide. So for example, the Los Angeles district, when it's approving the nationwide permits, has regional specific terms. I'm going to try again, a little louder. The edit is to reflect anytime we mention a nationwide permit that it expressly includes any core district's regional permits conditions. So when the nationwide permits went out in 2017, the Los Angeles district of the core issued some regional specific terms. We believe those are included as part of the terms and conditions of nationwides, but the request was just to make this very express so that people knew that this existed.
There's new language that's redlined in the paper draft that's not shown on the screen. And it's new language that says that the exemption applies only to discharges to waters of the U.S. I had thought that because we had language saying that the overall fill of state and federal water is required to meet the terms of the nationwide permit, which I think we were okay with. But I think you're saying the exemption would never be available for any water of the state with this new language. It's on line 169. Which, oh, there you go. I'm sorry.
That's okay.
Okay, go ahead.
It's the next slide. Sorry.
My fault.
No, it's not. It's that these things are, we mostly try to group them together, but they don't always fit together. All right, so this is under the alternatives analysis exemption, and it was pointed out to us clearly that the first Roman numeral, or the I, little I, was clearly a included both federal and state waters, and that it was ambiguous on Roman numeral 2. Was it federal waters or was it federal and state waters? So we put this clarification in to say this is what we meant, is that it only applied to federal waters. We understand that there are requests that it applied to more, but this is what we had meant, and that's why we clarified so that there wasn't any ambiguity.
So the result is, and again, this is in a mixed project situation. Somebody flipped a switch on me. So in a mixed project situation, the Romanet 1 anticipates, yeah, you count up all the state and federal waters together to see if you meet the terms of a nationwide permit, which would suggest that you're looking at mixed projects for this exemption. But under Romanet 2, you've clarified that the exemption is only available for discharges of waters to the U.S. So when those are read together, it seems to me that the only situations you will have are situations where you're doing a lead analysis on the state waters, but not on the federal waters. Again, you have a mixed jurisdictional problem there, and it eliminates the value of the exemption, I think.
I understand what you're saying. I don't, we did intend it to be different for state and federal waters, and we understand that that's not what everyone wants, and so we are going to prepare options that change that, but that's the way it was.
Thank you.
All right. Yeah, I want you to.
All right, so several of the different stakeholders that we met with wanted us to be explicit that we are discussing, and especially in this section, the exclusions from the procedures, that we're discussing some activities here that may or may not actually result in a discharge of dredged or fill material to waters of the state. That is a simple statement as to the coverage of these procedures. These procedures are for discharges of dredged or fill material to waters of the state. And we identify things like normal silvicultural activities, normal farming activities in these exclusions. Not every one of those even has a discharge of dredged or fill material to waters of the state. And so there is a concern, I believe, if I'm stating this correctly, that by listing things like planting seeds, that we were somehow suggesting that planting seeds always resulted in a discharge of dredged or fill material to waters of the state. So clearly it doesn't, not in all circumstances, not in most, maybe not in any, I don't know. So we thought that this new footnote would at least take away that potential implication that we were discussing those activities. And I think it's definitely not just the agricultural community, but many of the other stakeholder communities sort of read the exclusions and said, well, does this mean that everything that we do is necessarily a discharge of dredged or fill material to waters of the state? And this footnote is intended to say no. Oh, thank you. We may have the wrong number.
Yes, in the red line version that was circulated to last night, this is footnote 15. So it's in section 4D talking about exclusions, and the proposal would be adding it after the word activities.
All right. Now we're going to, we've got a few more before we take a break. I'm hoping that people can last out for 3 more slides. That may take a little while. The next one is a very inarticulate and a way of trying to address a concern. I will try and explain the concern and then try and explain why we couldn't do what we thought was the easiest solution. The concern is that we're describing here the procedures to regulate dredge or fill activities, and we also have a discussion that says that there's nothing in these procedures essentially that limit the regional board's authority to regulate waste. And so what we were trying to do was say that this is the procedures we want to use to regulate dredge and fill material. Am I on the wrong one?
Yeah, well, sort of. Oh, you're on the right one.
All right. All right. So, and so we were originally thinking that we could just say that that the regional boards cannot use any other can't issue waste discharge requirements to regulate dredge and fill outside of these procedures. But that actually then puts us in a position of it being a waiver of waste discharge requirements that need to be renewed every 5 years. We did not want to do that. And so we tried to figure out a way to signal that this is what we expect to be used, and And if you're going to try and do something else, that you need to let the executive director know, because we need to make that an issue. I tell you, I think it's inartful, and I think it's a problem, but we don't have a solution yet to this. And so we're trying different things, and we're open to having other solutions to this. But I'm probably going to say that, and I'm going to open up in a second for folks to talk, that this will take some one-on-one discussion with our legal counsel, because I'm not sure I understand it completely.
So let me just add a little bit to that. So the status quo today, which we were really trying not to disturb, is that to the extent there's a discharge of dredged or fill material to a water of the state, it does fall within the Water Board's jurisdiction. But the reality is that historically we have not been regulating the entire universe, and these exclusions here, the exclusions actually largely mirror areas that we just have not been regulating historically. So even though we do say in the, what is, I guess, for those of you who are following along on this version anyway, right at the very beginning of Section D, that the exclusions don't affect the Water Board's authority for those same excluded activities or areas if they have authority under the Water Code. We're not saying that they can't exercise that authority. We're just saying you don't use these procedures, these fairly specific procedures for applying for a permit. I think the point is that by saying that, it sort of alarmed some folks that we would suddenly come up with a different set of procedures, or the regional boards would come up with a different set of procedures and start regulating these activities where historically it just hasn't been a high enough priority for them to do so. And so one suggestion that we received was to say, well, if the areas or the activities are in fact excluded, then that means that the water boards cannot and will not regulate those areas or activities. That is what John was referring to as a solution that would actually require what would be considered a waiver of waste discharge requirements. We would be saying, go ahead and do the activities, we will not regulate them. There are in the Water Code specific provisions. The Water Code section is 13269 that apply whenever the board's adopting a waiver. There are conditions that have to be imposed. There's a requirement that it be renewed every 5 years. So in hindsight, looking at how those requirements would dovetail into a statement that we will not regulate these, staff sort of essentially concluded that wasn't really what we had in mind. We didn't really want to formally waive waste discharge requirements for all of these activities that are excluded. So I completely agree with Jonathan. This language may not satisfy anybody. It really, we put it here just sort of to illustrate this would be the most I think that we could easily do would be to add a paragraph to the board resolution that essentially says, you know, maybe provides a little bit of comfort that before a water board engages in some new regulatory activity that we have no plans, we know of no such initiatives by the regional boards, that they at least identify that they're going to do it and let the state board know about it. Again, if everybody says that it's not helpful, we are not at all wedded to this. And yeah, thank you. And by the way, this is an issue that comes up again this afternoon. So, you know, we don't expect that this is going to make everybody happy, this particular resolution of maintaining the existing language. So we definitely expect that some folks will propose some other version this afternoon.
Tess, you're going to save me.
So, and I appreciate the explanation because that's helpful to having you explain why this language was proposed, because when I first looked at it, I pretty much, you know, jumped out of my chair. I also think we need to think about it in context, and, maybe this is specific to the Central Valley, but, the provisions in the irrigated lands permits, in particular, the Central Valley general orders, where a lot of this would come up, I think covers, right? It wouldn't be a waiver because there are specific provisions and mitigation measures where you are dealing with potential wetland issues and discharges of sediment, et cetera, that I think might actually cover this. And I'll take a look at it between now and this afternoon. But yeah, I mean, I think clearly just saying that we're going to notify the state with the word EO isn't exactly very comforting, at all. I don't know that it provides any help whatsoever, and maybe we can come up with something else.
Yeah, and let me be clear, because I don't say things exactly legalese, but I'd say that we were trying to put in language to comfort folks that that these are the procedures that we would use for dredge and fill activities, but we can't seem to find a way to say that without invoking other problems. And so we're still open to trying to figure out a way to say that, because this is what we mean, but we don't want to put ourselves into a different legal issue. Okay, so this issue is related to the agricultural activities and concerns that the way that we described our exemptions for agricultural activities weren't complete or accurate, and how best could we do that? We have gone through multiple ways of trying to do that. And so essentially we're proposing to take out the tables that identify the different guidance letters and that we were trying to identify. We just took all that out. We then tried very hard to come up with a way that we could reference those without naming them specifically. And we run into a problem of referencing a guidance that isn't been identified. And so our last attempt here is to use the regulations portion and not specifically identify the guidance letters that may or may not change or may not be right. And it is our assumption that when you're looking at those, you will be looking also at any guidance that is applicable. Did I say that correctly?
All right, so I almost hate to do this, but I guess I have to. When we adopt rules, when any state agency adopts rules like this or regulations like this, they have to go to another agency called the Office of Administrative Law. And the Office of Administrative Law will look to see whether we've essentially followed all of their requirements for adopting regulations. One of their requirements deals with what they refer to as clarity. And they have interpreted this to mean very specifically that an agency in its regulations may incorporate by reference other agencies' documents. So for example, we are incorporating by reference right here on the screen the federal regulations that deal with 404F. The Office of Administrative Law is pretty rigorous, and I confirmed this with a conversation with one of their senior attorneys just yesterday, that any time that we are trying to incorporate other agencies' guidelines, other state laws or federal laws, we need to be very specific as to both the title of the document that we're incorporating and even the year, so that everybody knows which precise version we are incorporating. It's so that everybody knows exactly what the regulation does. So that's the lawyer's way of explaining what Jonathan just said. It reduces the amount of flexibility that we have in terms of referring generally to other federal guidance or other core guidance letters. Essentially, the Office of Administrative Law would disapprove our regulation if we tried to be that flexible.
Yeah, go ahead, Cook.
Hello. I think this may be the best solution achievable, given the difficulties in formulating language around consulting with the Corps and referring to Corps guidance. I don't know if Tess has other thoughts, but for the rest of the Ag Coalition, I think we're willing to let this one go and get on with business.
Well, if you all do come up with something, I'm open to it. We just couldn't find anything. We did go back and try a number of different ways, so.
I mean, I think it's probably true as a matter of practice. People are going to be digging those things out and sending them to regional board staff, so.
All right. We have one more before we're going to take a break, which is also one that we tried very hard to figure out a solution to, and we're still going to be working on, which is how do we deal with, well, let me back up. So for those that you weren't involved, our intent is that that we are not interfering with the with prior converted cropland when it's in agricultural production. We did propose that it not apply if there's a change of land use. I know that's a policy issue that folks want us to consider, and we are considering. Our attempt here was to explain that, and this is our original, which said that if it's qualified as prior converted cropland, they don't have to have the certification, but if it qualifies, then it would have the exemptions associated with it. The issue that was brought up was that qualified, we interpret to mean hasn't been abandoned, and so it still qualifies, but that it would be better to put in the abandonment language itself in there. We had a suggestion for that that caused some concern with our attorneys. They had another suggestion trying to actually go back to the abandonment language that causes some concern with folks. I think this is one we just need to continue to figure out. It's not that we've made a decision. I put this in, directed staff to put this in, because I think this actually does satisfy it, but it's not as clear as folks would want. And I wanted to make sure that everyone understands that we are proposing to mimic the approach for prior converted cropland, but that wording may have some difficulties still. I know it has some difficulties, but we're trying to get through it. I want to open it up for any questions.
Let me just to say exactly what John said in slightly different words. The area that I think that we were struggling with is the notion, and you can see it here in the middle of the slide, that the area qualifies as prior converted croplands. We think implicitly that certainly includes the notion of abandonment. So not for losing prior converted cropland status, but whether it initially gained prior converted cropland status and still has it at the point that we're evaluating it. We think it implicitly includes this idea of abandonment. Some folks had proposed a sort of a shorthand notion of abandonment. We were looking at something that was a little bit more precise. We just haven't been able to agree on a formulation of how to say abandonment explicitly. And that's where I think Jonathan's saying we're happy to continue to work at it. We're trying not to change the meaning of the way the Corps applies abandonment without adding, I don't know, 100 lines to the regulation.
So unless we have any questions, we're going to take a 15-minute break now. That is really the, yeah, go ahead.
One other thing, the Ag Coalition had proposed the inclusion of the 1986 preamble exemptions for certain ag features constructed in dry land.
Yeah, we are planning on talking about that. We're still, I think, having some discussion about the way the language works, and it's one of those that we're not saying that, oh, this necessarily is a policy issue. It's just one we haven't been able to get through in the last few days.
Okay, just make sure it's still on the table. Thank you.
Yeah, it is. And I will repeat for those that weren't here this morning that we had originally envisioned this as, these are clarifying language that we've talked to stakeholders about and we have clear understanding. And then after the break, we will talk about policy issues that people want to see changes, and that we thought everything would fit into those nice two categories. The reality is that there's some things that didn't fit very well in those two categories. We put them to the afternoon, after the break, so that we can talk about them and that we still have issues that we need to work through. Yes.
Issue, for those of us that are taking notes, where should we put that as a placeholder?
We're going to talk about it in the slides of what we called the policy, but I was trying to explain that that not all of those are policy. To some of them are just, we don't have the words yet, and so we've got an idea that we haven't had we haven't fully worked out with folks, and so it'll be after the break.
Jonathan, just one very technical item on the PC. Your sentence, this exclusion will no longer apply if the wetland area is converted, is not attached to the PC language, it's attached to the language about water appropriations. I think you have that sentence attached to the wrong paragraph.
Oh, thank you.
You're welcome.
So I'm going to suggest that unless there's any other questions on this, we're going to come back and have after folks had a chance to take a break, and if there are any other clarifying issues that we missed that you want to bring up that we talk about, and then we're going to switch to talking about areas where there are changes in the direction of the policy that people want to see. We have a list of them that we'll go through. I acknowledge right up front that we probably didn't catch all of them. We have been trying, but that's the point of this afternoon, is to talk about that and to see if there are areas where folks can come to an agreement that between different approaches. And so I'm going to suggest we come back in 15 minutes at 5:11. Thank you all.
test 1, 2, check, like this. And then make sure that they're not off, you know. So, like, see the green light? One, two, check. It's this one.
Okay, all right.
So I'm going to rush through right now with my attorney is away from the desk. I can get all sorts of things approved and move forward without him. So before we start in with the policy issues that we've identified, I wanted to make sure that somebody didn't have a flash during the break that they needed to tell me about for a clarifying edit that we missed or that we didn't talk about that was in the document that went out, and that because I'm sure there are some. And so and I'm going to make one more announcement is we figured out the AV people say if you don't hold it up straight up and down, and if you you have to be very careful because they're sensitive to the touch, they turn off very easily, so be careful with your microphones. And Clark, it looks like you have a comment, if you could. Why do I have that?
For the visual.
Oh, for the demonstration.
Yeah, and this is a technical one. We had some discussions about clarifying footnote 2 relative to modifications of waters of the state, to clarify that what we really meant is it's modifications of waters that are waters at the time and not at some point in the past. So was wondering what where we're going on footnote 2.
Clark, I'm sorry. I think I understood what you were saying, but the timing.
Yeah. So my understanding of staff's intent, as set forth in footnote 2, is that when you say modified water of the state, you mean something that was a water at the time it was modified or eliminated, rather than something that might have been a water in the past. And then converted.
Yeah. So just so everybody can follow, it's I think it's footnote. It was originally footnote 2. Now it's footnote 3, and it doesn't show any changes. And the issue is, what does it mean to have been directly converted from a pre-existing water of the state? And we didn't actually come up with any specific language, but absolutely I think we showed you 3 or 4 formulations in our meeting. If any of those make sense, we're happy to include them, or others.
Yeah, I don't think we saw those formulations, but the CBI coalition did offer an amendment to try to get at that intent that went over Paul on Monday night. If you look at our red line.
Monday night?
Yeah, Monday night. Okay. It's just one shot at making that clarification.
So for the other people that have no idea what we're talking about is that in the discussion about a wetland created or by modification of waters of the state, what we intended is it was directly converted and not historically. And so we're trying to get that straightened out to make that clear.
We also, water agencies and stormwater agencies also talked to you about that footnote 2. We also submitted language, I think last night, Tuesday night, to deal with this directly issue. We had also discussed a little bit in our meetings whether diversion to get water there should be considered, and degree to which historically converted floodplains in such areas as that should operate to limit or eliminate the exclusion. So we also submitted language on those topics.
That's great. We consider that part of that directly converted on the floodplain issue. And we'll look at what you have about the diversion structures. We clearly didn't mean for a diversion structure to create where the water goes doesn't necessarily become a water of the state. The diversion structure itself is likely in water of the state or the water of the U.S. and would be covered under these, but the other wouldn't. And so we do recognize that. We're making note of it.
One other clarification that I know you made changes, but I don't think we discussed this morning, was additional clarifications from our prior stakeholder meeting on temporary impacts, particularly those associated with O&M of sort of existing naturalized facilities, and the degree to which those should require compensatory mitigation as opposed to mitigation via restoration. and we talked a lot about those self-mitigating projects and such. So we also submitted clarification language to that section, which is IDA 2D, and had some additional suggestions on that section.
Marilyn, was that also last night? And those, okay, so we haven't had a chance to look at that yet.
Right.
I don't think that was on the list of things we agreed needed language, but we'll definitely take a look at it.
I had it on my list, but we could have different lists.
So, yeah, Tess.
Okay, so this is going back to the last language you put on the prior converted cropland, and this is more of a question for clarification, and maybe it's somewhere else in the policy and I just missed it. But when we use actual incorporation of references to the federal regs, which version are we referring to? Because the definition of prior converted cropland has moved around and is not always 8A, and actually I don't know if it is right now or not, because I don't know which version we're currently under, thanks to the courts and everything else that's going on.
So for the regulations, at least, we think we're identifying the right one by date. And that is our goal, is to identify each of them by date in order to satisfy the Office of Administrative Law. But
Okay, yeah, because it was for the language you just put up, it does not include the date.
the language, which
Second, we're looking, because we might not have got the right things on there.
We added the date that was deleted. We plan to add it. We're looking for 19.
got it. So for all of those references, I think we may have missed adding dates for a few of them. Definitely, we will have a specific date for all of them.
And by the date you are, okay, so you'll let us know, is it 2015, 27, whatever version of the regs you are referencing to?
Exactly.
Okay.
Right. And if it's the wrong one, by all means, let us know.
Okay.
Yeah.
And just to make you feel better, we're not going to go look through and find which version we like the best. We are going to pick the one that we think applies today.
Line 482, that is referencing.
Okay, so at this point, I'm going to move on to issues that have been raised to us as considerations for changes in what staff was intending or proposed. I'm not going to claim that we got all of them, and as you've been hearing, we've been we've been having meetings and we've been getting suggested changes up until late last night, but we tried to capture them, and we're going to go through that. My plan, my hope, is that we'll get through those, and if any other ones that folks haven't told us about, that they could articulate what their concern is, and so we can try and get it jotted down. We are going to, and then I'd want to see, based on people's comments and concerns about those changes, that there may be some that we have a kind of a broader consensus that this is not, that change is, in policy is generally accepted by everyone, so that we know that. Yes, Dee.
Just out of interest, however possible, to get us closer to agreement where possible, which I think will be very difficult in many of these. But if stakeholders could also indicate priority of interest on any given topic, that would be helpful. So for example, I think on the first topic, there's several different iterations with different approaches. If folks could please indicate what their number one priority, and then down the line, that would be helpful.
Thank you. And I reiterate that what Board Member Diadama was saying is that if this is not an issue for you, one of the changes says it doesn't matter to you, it'd be good to know that. If it really matters to you one way or the other, it's good to know that too, so that we can try and figure out where things are. And so then finally, what we're hoping to do is take all these ideas for changes, figure out language that would support that change, and prepare options for the board to consider on those. So I'm going to jump right in. And as you'll notice, as we go through these, there are different levels of development of the idea. Some are easy. This one's remove the exemption from alternatives analysis for all projects. That's pretty easy to do because it's just a deletion of all that section. That was a request that we had. So as you can see, we can kind of do that one pretty straightforwardly. Some of the ones that we have will just have the concept, and we haven't figured out how to implement that concept yet. So this is one of a number of issues related to the exemption under the alternatives analysis section. And I'm going to try and go through those. They were submitted by our restoration and NGO community, and I think they're kind of in order of priority. And if I'm wrong, let me know. But this would be their top asks. Why don't you just get rid of it? We think alternatives analysis should be done for every project, and that's the most protective. And then next, if that's not doable, what about adding some additional conditions for when a alternatives analysis would be required? And you guys don't all have to write all these things down. We're going to make these available. I just didn't. I think we have them, don't we, at this point?
The slide deck? The
Yeah.
slides? Yeah.
Where are they? Printed.
We don't have printed.
Yeah, okay. So we'll make them available on our website. We didn't have a chance to print all of these. We've been working on them the whole time. But we'll be able to flash back and forth to them if people have questions as we go through. I want to get to so this one is the idea of adding a couple of 3 additional conditions on this exemption. The projects that require a pre-construction notification to the Corps. High conservation value subwatersheds is identified in this conservation blueprint document, and headwater streams as defined to the first to third order streams. I think there's one more on this group. Is that correct? Okay. So essentially, the idea here is this is one set of different proposals. I'm assuming that we got it pretty much correct because we got red lines from them to do this. Is that correct? So. All right, so we'll move on. Oh, yeah. Question?
Thank you. My name is Mark Harrison, and I represent a group of construction companies, construction materials companies, and land development companies. And I think it's appropriate as we're moving into the section here talking about the language of the regulation itself and then alternatives to the language for us to be mindful of the fact that as the board goes forward, the board, both legally and I think as a practical matter, needs to be mindful of the impacts of this regulation. And in connection with that, I took the time to go through the functional equivalent document. I think you call it a substitute environmental document. And I know staff doesn't need more work to do, so I'm apologetic to say this, but I think it's really important for the board to have this information. I'm gonna just identify 3 examples, and so one, for example, is mineral resources, and that you'll find it on the staff report around page 179. And fundamentally what it says is that staff doesn't have information on the impacts of this regulation on impairing or sterilizing mineral resources, and therefore they make the conclusion that the impact is less than significant. And I'm certain legally, and also I think as a practical matter, there has to be a higher level of investigation. And fortunately, there is a repository for information which will inform that analysis. So the State Mining and Geology Board, by statute and through the vehicle of regulations, has identified regionally significant and statewide significant construction materials resources. They actually identify them with precise locations. And then under SMARA as well, each city or county that has a mine is required to identify that mine and its particular characteristics in its general plan. So there's a repository of information that's in the possession of a sister agency that's available to look at to inform that analysis. And why it's so important is because under SB1 and some of the other initiatives underway, whether it's housing or otherwise, access to these construction materials is critical, and the state is short on them. So that's one issue. The same analysis, which basically says we don't have information and therefore we find no impact or less than significant impact, applies for the discussion of population and housing and traffic and transportation. And population and housing, we know that general plans are required to be kept, and each county has to have a LAFCO, which identify usually in great detail the growth areas and including, among other things, the biological characteristics of those areas. So you would have available, you do have available data that could be used to inform the board about the impacts of this effort to protect one resource and what environmental impacts it will have on also other important resources in the county. And the same applies for transportation. So for all of the growth areas of the state, you have a transportation authority, and they prepare metropolitan transportation plans, which identify again in rather great detail exactly where those transportation projects are going to take place. And thus it would be a source of information for the board staff to use to analyze the environmental impacts and then inform the board of those before you go forward. And if the project impacts aren't analyzed, then the cumulative impacts are impossible to analyze because cumulative impacts are a collection of the project level impacts. So those are high-level comments, but I think I wanted to make them early in this process because they influence really the whole process of analyzing language, the project description, and also alternatives. So thanks for the opportunity to share that comment.
Appreciate it. Yeah.
My name is Mike Jocelyn. I'm with the environmental consulting firm WRA. And I wanted to comment, this is also a very general overall comment too, as well as to the policy and perhaps its more practical implications. And that is that as terms are put together now, essentially any project, no matter how small, that has a wetland or an eelgrass bed or affects a habitat for endangered species requires the Tier 3 analysis, alternatives analysis, both on and off-site. So even a wetland of 0.01 acres would require that type of analysis. The board staff provided a white paper on the number of permits that might be implicated by that type of thing last week. And we were able to look at that document. It was very useful, thank you, and including the database that was used to put that together. You know, one of the things we also realize is that the language now, as it even relates to temporary impacts, says unless it impacts a wetland, that would also require an alternatives analysis. And of course, any project that affects a stream of 300 feet or 200 to 300 or 100 or less than 100 required one. So we were able to use the database that the board staff provided us and determined that 1,265 projects during a 3-year period that were identified by the board would have required a Tier 3 alternatives analysis. 114 would have required a Tier 2 and 272 a Tier 1. Now, there are practical implications to any regulation. They require more work by applicants, and they require more work by regional board staff. So we looked at, based on our experience, and our office is located in the San Francisco Bay Regional Board, we prepare a lot of alternative analyses for projects that are of low acreage, that are below the half an acre that's normally associated with nationwide permits. So we have a pretty good idea of the planners that are needed to do an alternatives analysis, both on and off site, engineers that have to look at the projects and look at that, biologists, as well as attorneys and the applicant itself, in order to evaluate a number of kinds of alternatives. And they're expensive documents. They can be 100 pages or more, evaluating a lot of very technical data. This requires the board staff to review that, to look through it, to make analyses, to help with, what is the overall project purpose? What is the evaluative criteria? So the board staff have to be intimately involved in that process. So we took those numbers of permits and just equated them to a year, what it would take per year to look at. And we came up with projects in each one of those, and also looked at what our average cost and that of other applicants in preparing alternative analyses in those various tiers, as well as what staff time might be involved. So we determined that the total cost to applicants per year across the state would be about $30 million in preparing documents for that. We also determined that the staff time involved would be on the order of 13 full-time equivalents that would have to be added to the staff in order to make that type of determination. Now, you also put in there that some regional boards already require alternative analyses. We know of two, the Region 1 and Region 2. We took their permits out. That's not new staff. They might want to have new staff, but if they're doing it already, thank you. That came to be about 17% of the total, so that would require that the FTE be only about 10.6 across the state. So I wanted to bring that attention because that is one of the bases for perhaps restricting not all projects that have wetlands to be in a Tier 3, and not all projects that are temporary to be in a Tier 3. We think, the implications to the state budget in order to hire that amount of staff would be very significant, and that doesn't include all of the other elements that it would be associated with, this new policy. Thank you.
Thank you.
Kim Delfino with Defenders of Wildlife. First, it's an interesting observation. I would just say my understanding is with respect to the San Francisco Regional Board that they currently don't have this level of an exemption this actually will be probably a reduction in workload for the staff, but that wasn't really the point I was trying to make. I just wanted to clarify with respect to this particular exemption that's up here. First, the conservation organizations have only raised an issue with this particular exemption. The other exemptions you've proposed we're fine with. I want to make that clear to the other folks that are sitting in the room, which according to your own analysis would allow an exemption of about 40% of projects. With respect to this particular exemption, those three, the E, F, and G that were proposed, we did not propose them as all-inclusive. We were giving you a menu that you could choose one of these three as an additional, as something that you could add. So, for example, while we would love to not have this exemption, in the alternative, you could simply add in projects that are required to submit a pre-construction notification to the Corps. That might be the easiest. We've talked through what some of the other issues might be as they relate to water streams, or folks might not be comfortable with watersheds identified in the freshwater conservation blueprint, but I just wanted to make it clear to the folks sitting in the room that that's what was being proposed.
I really appreciate that clarification because I was doing shorthand of, all of them, and really what they had proposed was that these are additions that could be considered, not necessarily that all of them come as a package.
I guess the question is, do you have policy alternatives that have been advanced by the other coalitions? There's more slides? Okay.
Oh, yeah, we got dozens.
On this issue?
Yeah.
Okay.
All right, so why don't we go to the next one? Oh, wait.
I just wanted to clarify on one of our proposed, Karen High with Citizens Committee to complete the refuge, on item E, where it says projects are required to submit a reconstruction notification to the Corps. There are many nationwide, uncertified nationwides that currently require notification, and included in that notification is a scaled down version of an alternatives analysis, so it's not a full-blown, it just may be methodology, materials used, something of that sort. So it is already required, and for many of these PCNs, it's regardless of the size of the impact. It's just anything that fits in that particular nationwide permit box. They would be required to submit this scaled down version of alternatives to the Corps already.
Understood. All right, I'm going to move to the next one. So this is the exact opposite, which essentially was a request to remove the requirements to do an alternatives analysis if these, any of these went. So essentially what this one is trying to suggest is that if it's got a exemption from if it's an uncertified Army Corps general permit. Right.
Sorry, this one goes even further. This one removes the requirements for an alternatives analysis for any projects permitted under a nationwide permit, whether it's certified or not. Yeah.
All right, that's what I was trying to say. I guess I didn't say it. So I see this as the kind of the mirror image of the first one, which is ask for alternatives analysis for everything, don't ask for alternatives analysis for certified. So I think we have some, then if we go on, we have some some more nuanced to reduce the exemption. So this talks about, and these are essentially the same kind of thing. You don't have to say that they all go together, but these are, on the same issue. Changing from 2/10 to 5/10 of an acre. So that would raise the size of that would qualify for exemption from alternatives analysis. The next one talks about clarifying that habitat has to be occupied. That's was another suggestion, and then there was a suggestion that that having wetlands as a site is too broad of and it would capture too many projects. So removing that and using the eelgrass beds only. I think that's kind of the range of those suggestions. And as I said, we will be making options available for the board. I want to give folks an opportunity if they think that there's some combination of these that everyone agrees with. We could do that, but I'm really, this is not really one of the ones that I thought that there is that level of understanding. Yes. Wait for the mic, please.
My concern with A on this one is that it may.
So I don't, I'm
You
not,
want-
I'm not really, I mean, you can give your concern. I just don't think that, yeah, go ahead. I'm
I
sorry.
just want to point out that this could potentially introduce an inconsistency with the Corps' own nationwide permit boxes. Some of the nationwides have requirements that are more restrictive, so they're less than 5/10ths of an acre. And they don't talk about occupied habitat.
Just to be clear, I think if a nationwide had a restriction that was lower than 0.5, I would think the language would say it wouldn't meet the terms and conditions of a nationwide. So that's how under this proposal, that's how I think the language would interact.
I don't know about that.
Yeah, this clerk would just clarify that there are nationwides with lower limits, but there are some very important ones that have a 0.5 acre limit, particularly for residential, industrial, and we were concerned that squeezing that down to 0.2 would be problematic. I would just say I don't want to lose. There was one other policy issue out there that we discussed this morning, which is mixed projects, that issue, and I don't know whether that's a clarification issue or whether that's a policy issue. It feels a little bit like a policy issue to me because the most recent draft said federal waters.
Yeah, are you talking about the, where we talked about, where we had put in the words waters of the,
yes.
Yes, I consider that a policy issue, and I don't know if it's in one of these slides later, but we do recognize that as an option that could also affect it.
It is not in one of the future slides. However, the language on the previous or the first alternative could easily be applied to the second alternative as well. So we just harmonize the language between the first two.
You're talking about the tiers?
The exemptions.
Yeah, okay. Yeah. So we understand it. They got it down. I just said it the wrong way, as happens all the time.
So I asked them to go back one slide. I think what we're saying is the edit on the screen, the first edit, you could make and say this applies to all nationwide permits, and then
that's not the I don't think that's the issue, but I do understand the issue. The issue is that right now we made it very clear that certified nationwide permits count for waters of the U.S. and waters of the state. Uncertified only count for waters of the U.S. And the issue was that should apply to waters of the U.S. and waters of the state. Well, but this also does all sorts of other things.
Make sure I made the discussion this morning. So you're suggesting that for certified it applies to both, but for uncertified it applies only to waters of the U.S.
That's correct. That's what we had discussed this morning, and I thought that the request was to expand the uncertified to both. Okay, I'm going to move on to one that may be a little less contentious. Yes?
Hi, Brad Johnson here. Just a quick comment before we move on. In this discussion, we've talked about a huge range of impacts from this rule. We're talking about when alternatives analysis might be required and when alternatives analysis might not be required. And you're making these changes, or you're at least debating these changes in a staff workshop here during a period of time when you've said that you're not accepting any written comments from the public on these, on these issues.
So, excuse me, I get what you're saying, but we did get comments on all of these issues, and we're trying to clarify those so that we can give options to the board.
Right, so I understand that. And you received written comments 17 months ago, and then in the intervening time, you released a draft that was revised by more than half, with the intent, at least when it was originally released in January, to adopt the thing 30 days later. And although there hasn't really been any discussion from staff on the basis for not accepting public comments, we understand that the idea that you're pointing to is something called the logical outgrowth test, which is it's a federal doctrine that finds its basis in the federal APA and the Federal Clean Water Act and federal case law. And it's actually not something that's in statute, it's something that's an outgrowth of case law. And so the idea is that with this logical outgrowth test, if a revised regulation can be considered a logical outgrowth of a previously released draft, well, then the agency isn't required to recirculate the revised draft for additional round of public comments and responses. But here, that's not really what's happening. What we see here as what's happening is you're receiving written comments in the form of red line suggested changes. You said you have something like 500 pages, right, that you're running through. And you're doing that in a context where you're meeting with stakeholders, you're receiving these red line comments, but you're not disclosing to the public who has offered these comments, which comments exactly you're incorporating in your various iterations here, and you're not disclosing that to the board either. So it's not a transparent process that we're seeing here. But I think it's also important to note that the logical outgrowth test isn't even met here. So certainly you as an agency are allowed to make clarifications, but where your clarifications actually broaden the scope of the draft rule, the logical outgrowth test doesn't provide any protection. Also, as we know, there's a lot of confusion about what this rule means. We saw that the last workshop, we're seeing it again today. I mean, if I can't count on both of my hands and my feet the number of times I've heard staff say, that's not what we intended. And the sources of confusion, or at least articulated confusion, these aren't uneducated folks. These are sophisticated stakeholders, the primary consumers of this rule. And so I'm asking the board, or at least making the comment here, that the process that the board seems to be following is one where you had the prior rule circulated for public comment 17 months ago, significantly revised. Now you're pushing it forward without receiving any written comments. I want to make that clear to everyone here. Everything you're submitting, as far as staff is concerned, has never happened. It's not in the administrative record for purposes of this rulemaking. But what we're seeing is you actually working through, making substantive changes, having additional discussions that are not occurring in a public forum, that are not transparent, where people are not putting their name on their comments and you're not responding to them in a written, comprehensive way. And what this is going to culminate in is an entirely different version of the rule that's going to be released sometime in advance of the board's March 5th hearing. So in terms of the federal doctrine, it doesn't work. But in terms of just good governance, I think we all have to pose the question, why wouldn't we actually open this back up for another round of real public review, real comments, real responses, and then in a timely fashion, not 17 months down the road, but in a timely fashion, move this forward to the board? Because right now, nobody knows what's going to the board. Thanks.
So thank you. I don't want anybody to be under the misimpression that all of the things that we have on the board here today will necessarily go to the board and the board will necessarily adopt them. What we're doing is trying to present language options for the board. If at the end of the day, the board wants to adopt something that is truly significantly different than what was proposed back in 2017 and that we did take public comment on, we will, of course, have to reevaluate whether it warrants another comment period. There's no question about that. But we're not there yet. It would be premature for us to say that what's ultimately going to be considered by the board is necessarily that different from the earlier versions. But appreciate their comments.
All right. Next. So we talked about this morning. We tried a some language for clarification, but it was clear to us that there were other options that might work better, but that would change the structure of the tier system. And so this idea is to take the operation and maintenance out of tier 2 and put it in tier 1. Right now it's in tier 2 as a captured under the idea of projects that inherently can't be moved, and that and so that's where that was. We don't yet. I know that folks have talked about language, but we haven't had a chance to do that yet. But this is one that has been discussed and proposed. Sure.
So this one seemed like in meetings with staff, it seemed like one that we were close to consensus. At least it seemed there was a meeting of the minds in some ways that the concern with doing on-site alternatives analysis for operation and maintenance of existing facilities, which can be, hundreds and thousands of acres in some cases, I mean, very large areas, is you'd potentially be having to look at, moving existing facilities that have been there and performing functions for a long time. So what we thought about, what was important about tier 1 was just the avoidance and minimization when doing, when you're required to do this, whatever triggers it, when you're required to do it, it makes sense to be looking at your practices. Are we doing this in a way that, are we doing it the best way we could? But having to consider, I got to move Perk Pond 3, a half mile away, which is all my property. Those are the kind of things that it could be really disruptive to the overall, these critical projects that are carefully designed with a lot of different agreements and with a lot of regulatory oversight already. And so that's the reason for the proposed change. And we provided some language that I can read it or you guys can look at it, but I think it could be done by moving the language from avoidance minimization language up from tier 1 to tier 2, or you could just put O&M projects for existing facilities into tier 1, either way you want. But one thing that never made it into this draft that I think needs to be clarified is that before staff had suggested a footnote that indicated inherently water dependent, or that O&M of existing facilities would be inherently water dependent. That's not in the current draft, so it's not clear as it's currently drafted why you'd be, why O&M would even be in tier 2. So that linkage which you had before never made it into this cut. So you have language which is in there, but there's no linkage as to why O&M is inherently water dependent.
I'm brilliant. Yeah.
So when we talk about existing facilities, you're right, there are certainly existing facilities, particularly the ones that you're interested in, that are very large and we would agree are almost certainly infeasible to move. We thought that the language in tier 2 made that clear. Clearly, we're hearing that it's not. It's important to note that we also have facilities that are very, very small that may do O&M. And those facilities may be entirely appropriate, and it may actually be in the applicant's interest to move those facilities. So there's a middle ground here that we have to be able to reach. There's a couple of different ways that we can do that. One of the ways that you've proposed is that we explicitly identify O&M within the tiers. Another way that we can do that is just go on record and saying, yeah, we recognize that flood control agencies are kind of an odd beast, and we recognize that those are likely to be infeasible to be moved. So one opportunity was to do the footnote, which is language that we floated earlier. That's not the language that we're presenting here. It's certainly something I think we could revisit.
Okay, it wouldn't just be flood control. I think Mr. Flood Control is going to be speaking in just a second here with Dave for his agencies, but it would be water agencies as well. The key is if our overall view is that for existing facilities, we shouldn't be getting the new permits in the first place. It doesn't make a whole lot of sense when you have existing facilities that have already, and we've talked about this, but to the extent we are required to, you certainly don't want to require an alternatives analysis for something that's already in the ground and that really, in all likelihood, is not going to be able to be moved very much or changed very much.
We agree.
Okay.
We're trying to get there.
So just to add on one thing that may clarify that, Paul, because you've talked before about other types of facilities, primarily in reference to utility lines and things of that nature. So one of the reasons we liked that draft footnote 14 that we reviewed mutually together last Friday is that it did create a connection between water-dependent facilities that have to be located where they are and a distinction from other types of smaller facilities that might be able to be moved around. So that's why we're in favor of retaining that draft footnote that we all reviewed together, and then just specifically referencing the avoidance and minimization language for this analysis when we're talking about O&M, which is, I think, what you're primarily addressing with the red line we see today.
Yeah, Dave Burhan, I'm outside counsel for LA County Riverside Flood. I want to second and third what Jeremy and Mary Lynn have said, but I also want to add this thought. It's not so much about, it's about moving, but you're not going to move a debris base. You're not going to move a flood control channel, but these are subject to repetitive and fairly highly conditioned activities. And we've talked about this. The LA soft bottom debris channel, flood channel permit is extremely specific. There really isn't, I mean, I think the alternatives have all been thought through. And so to me, this is reinventing the wheel and potentially adding delay to a process which is already pretty extensive. So, I mean, I guess that is a reason to support the tier 1 language, because you definitely have to consider impacts on waters of the state. That's right out of the 401 cert regs. So I think that is appropriate. So I would urge that we move the tier 1 consideration language into the tier 2 projects for this O&M. I wouldn't necessarily limit it to stormwater and flood control. I like that, but there also are, to the extent there are water conservation agencies that may not do flood control, I think should apply to their kind of operations where, again, it's routinized and, it's really not a lot of discretion involved. Either you clean it out or it doesn't work.
Great, thank you. All right.
I know you guys already know this, but just we did provide language. Hopefully you'll take a look at it. Maybe it'll work for you.
Okay. Rebuttable presumption. Different options for dealing with it. We gave you clarifying language this morning. These are other ways to look at it. So one approach, essentially they go on either end of the scale, is the way that I read this. Am I reading that correct? One is that we wouldn't apply the rebuttal presumption to, that's what it already is, isn't it? Isn't option one what today is?
Not federal lands.
Oh, not. I'm sorry. I didn't read the word not. So, so it would be apply that to all state features, state waters. Okay. Yeah, that's all right. And I don't know what the second one. Yeah, go ahead.
So the second one basically was a request that we revert back to the existing core definition and then address the rebuttable presumption separately. The observation was that from the stakeholder that proposed this was that they didn't see that our procedures provided any regulatory effect that required a different definition from what the core uses than the rebuttable presumption language. So he proposed that we revert back to the core's definition and treat the rebuttable presumption separately.
think you've characterized option 2 correctly. I think what you're saying is we use the federal wetlands definition, and because that would leave out modified 3 parameter wetlands, the ones with no vegetation, add those to the list of items that would be subject to the rebuttable presumption, right? That's how you would address rebuttable presumption under option 2.
Okay.
That's my read on it. Is that correct?
Well, speaking frankly, Clark, this is your proposal, so.
Well, I wanted to make sure your intent was lined up with my intent for the proposal.
If we have mischaracterized your proposal, then send us language again.
Okay, fine.
This is Kim Delfino with Defenders of Wildlife. I guess I'm not entirely sure what you want me to say about this, other than maybe it doesn't come as a great surprise to you that I don't think either option would be acceptable to the environmental community. And I'm not sure if I'm supposed to weigh in and tell you that or not, for obvious reasons. I mean, certainly harmonizing the wetlands definition with the Corps' definition is exactly what we are not okay. I mean, the Corps' definition is shifting, so.
So I understand.
But I felt the need to say something.
That's fine. I guess that our assumption is if we don't hear anything from everyone, that we assume that you're not necessarily agreeing. If you think that this is just fine, let us know. On that. I don't know. We didn't think this through in a very structured way. We're just trying to make sure that all of the issues are out on the board on the floor.
I'd like to respond to Kim on option 2. What we're really trying to do is not change the effect of the definition, not change the effect of the procedures. And the way we're doing it is you go back to the current definition of wetland. But the Corps is not proposing to change the definition of wetlands, by the way. It's just changing the definition of waters of the U.S. So you use the Corps' definition of wetlands to eliminate the inconsistency. The delta between the Corps' definition and the proposed state definition, the thing that falls in that gap are what staff is calling a modified 3-parameter wetland, that is a wetland with no vegetation. So our proposal would be to just deal with that separately and make sure that those modified 3-parameter wetlands are protected as if they are a wetland. But don't call them wetlands because they're actually not wetlands. As we understand them over 30 years of practice, that definition has been in place for a very long time. So our proposal is to offer the same substantive protection to modified 2-parameter wetlands as is currently in the procedures, just be consistent with the federal definition of wetlands. So it actually should be acceptable to the NGO community because it has no change other than symbolic.
I think the NGO community understands what Clark's asking for, and no, we're not okay with that. And the definition of wetlands has been the same definition. I mean, to be quite blunt, the environmental community, we're not getting everything we wanted in the wetlands definition, but this definition has been what the board has been proposing for several years now in this 10-year-long process. I think we would have thought a 1-parameter test was a more appropriate, but this modified 3-parameter test that you're proposing, we're willing to live with because, frankly, we would like to see this policy get done by the time, maybe by, before I retire. So, yeah, just want to be clear about that.
Great, thank you very much. I'm going to turn the next 2 over there on climate change to Paul, because I didn't get a chance to go through these last night. Oh, yeah.
So, I'm sorry. Go ahead, Didi.
Can we go back to option number 1? I just want to better understand how option number 1 might play out. And Clark, since this is your language, the special aquatic sites. Could you explain a little bit more?
And I want to make sure I'm not throwing Clark under a bus. When I say this is his language, I meant this is staff's paraphrasing of the concept as we understood it from Clark. This does not actually reflect actual language that Clark's provided, and I want to be clear about that because I don't want to throw you
Appreciate
under the
that.
bus.
So Didi, you were asking really about option one, I think. I'm trying to figure out how to characterize this simply. The rebuttable presumption under the Corps' regulations applies to wetlands and certain other types of non-wetland features. And there's a list of them in the 404B1 guide in the regs. Option one is saying that you only expand the type of features that are subject to the rebuttable presumption. That is, the rebuttable presumption under federal law applies to wetlands and other special aquatic sites. And those special aquatic sites are these other types of features. So our preferences just don't apply the rebuttable presumption to anything that doesn't currently receive that protection. Option two, one and two are sort of trade-off for us because we would obviously like to see the state go with federal definition. And our thought in option two is trade that for adding modified three-parameter wetlands to the list of items subject to the rebuttable presumption. So two is, in a sense, something of a compromise. Our preference, of course, is one.
All right, Paul, would you take the ones on climate change for me?
So we heard a number of different alternatives for how to address climate change. They ranged from the first one that I'm going to talk about, which is that we modify the language so that in all cases, an assessment of the potential impacts associated with climate change is required. There's the second option, next slide, would be to simply restore the 2017 language, which would be similar. It would still require an assessment of potential impacts associated with climate change, but it would make it a staff discretionary request. So it would not necessarily be required for all projects. Next slide. The counter proposal to that has been to either delete the climate change analysis requirements outright, so we would not require a climate change analysis for any projects under these procedures, though they might still be required for other types of activities such as CEQA, or alternatively, if we are going to retain those climate change analyses, that we request to the board to direct staff to develop guidance on how that climate change should be assessed. So that's kind of the range of options that we have. Some of those have specific language and some of them don't.
All right. I'm going to suggest that we take one or two more and then take a lunch break. There is quite a number still to go through, and I feel like we'll be all more responsive if we have some food and blood sugar. So the next one is define ongoing operation and maintenance on a temporal basis. I don't know what that means, Paul. So I just want to let people know that we were spending a lot of effort up through the last week trying to get all these down, and so we haven't had a chance to go through all of them in detail.
Yeah, so this one, our jurisdictional framework talks about, help me out, Phil or Serena. I'm sorry, I found it, yeah. So it talks about a number of artificial features that would be considered waters of the state, and there are some exclusions from this. One of those exclusions talks about greater than or equal to 1 acre in size unless the artificial wetland was constructed and is currently, sorry, I'm the wrong one. Number 3, resulting from historic human activity is not subject to ongoing operation and maintenance and has become a relatively permanent part of the natural landscape. We've had some questions about, okay, well, at what point does it stop being subject to operation and maintenance? Does it stop being subject to operation and maintenance the day after you've actually done that O&M work, or is it some period after that? And there's been some requests to clarify and to put some sort of a time component to how long it would need to be after it was operated and maintained. So I could envision this being something similar to, you know, the 5-year abandonment clause that we would do for PCC.
Thank you. I have to go back to climate change. I'm sorry to go backwards. You know, in getting projects approved, climate change is a real difficult issue. We've got guidance from CARB. We have guidance from air districts. We have guidance from the Supreme Court. And I'm not sure that there's any attorney that practices in this area that could tell you with absolute confidence what's actually required and how actually it gets done. It's a very changing, complicated area. So in the context of a climate change analysis for, let's say it's half an acre where you're putting in a turnout facility for a groundwater recharge system at the end of a mining operation, for example, which is something that I encounter pretty often. How would you do it? What thresholds would you analyze it against? And would Water Board regional staff actually do the climate change analysis? Or how would that work? Because that doesn't seem to be something that's within their area of expertise.
The language that's currently proposed, that was the staff's proposal that we provided clarifications for this morning, talks about looking at climate change with regards to permittee responsible mitigation. So for your hypothetical situation, what we have proposed is that you take a look at, if you are providing permittee responsible mitigation, do you have the appropriate adaptive management program in place to ensure continuance of that mitigation over the course of however long that mitigation is to be provided? For these other climate change analyses, we would have to think about that more. These are alternatives that I think we can provide some information for some of them. Others, I'm not sure. I think we would probably want to go to the board to request that we develop the guidance. John.
So actually on that point, we did, I think at the staff level, we were thinking that the last sentence on this slide might not be particularly objectionable to anybody, but it'd be good to get some feedback. The idea here is assuming that the board retains some requirement for climate change analysis. As Paul said, right now it's just for the mitigation, permittee responsible mitigation. But assuming that that happens, or perhaps it's expanded in either case, the idea with this last sentence is that the board, in adopting the procedures, would direct the staff to work with stakeholders and develop some guidance on exactly how this could happen, how the analysis can and should happen, what kind of sideboards, what kind of scope we're looking at. Is there anybody who just sort of on the face of it would object to that kind of direction to staff?
I don't object to that at all, but what I think it's important is it's something that has to be in the regulation because it could be incredibly impactful. So to take my hypothetical again, so the reclamation for this particular mine is to leave a groundwater basin that then a flood control district happens to be in the Bay Area uses to recharge the aquifer. And the final step of reclamation on a project that's already been through CEQA and been approved is to construct a simple turnout structure in a ditch, essentially. So the water district, when the water conditions are right, can turn water into the groundwater recharge facility. So what would you analyze from the standpoint of climate? There's a couple outstanding issues. One, this is already an approved project, and this turnout facility is required. It's not, and the only discretionary quote-unquote element is the need to get a 401, and the underlying activity is allowed under a nationwide. So it just seems to me that this issue is so important that just deferring it to guidance later is kicking maybe one of the fundamental issues down the road too far.
Understood. All right, I'm going to suggest one. Oh.
Just have a follow-up question similar to what's being discussed. So what would be the purpose of the state board or regional boards looking at climate change, and to what end?
So I don't know that I can answer all these questions because this was a request to add climate change analysis to the project. My understanding of that is that is there going to be an impact to the project? Are you going to build a project that's going to be underwater in 5 years? Have you analyzed that? Have you addressed the issues related to sea level rise or changes in water supply based on it? That was, I think, the request. It's not a staff request, and so it's harder for me to be answering those kind of questions that folks are bringing up. And you're now going to tell me something else.
I'm just going to clarify that I think, at least my understanding of the draft rules that were released on January 3rd were that the requirement is to analyze.
Yeah, that's not what you guys asking about. This request was should we expand that? Yes.
No, I understand that, but the proposal was to analyze the impacts of climate change on the mitigations, not on the project. So the analysis would be, if you're going to be constructing these mitigations, are those mitigations going to be impacted by sea level rise or airification or whatever?
Yeah, well, that's correct. That is what is in the proposed draft. What we're discussing here was a request to expand that to the project itself. Okay.
Yeah.
All right, I'm going to give one more, and then we're going to break for lunch, because I'm getting testy, I think, because I've not eaten. It's not up yet. No, we already did this. Next. Well, I thought we already talked about it once, but maybe.
I just wanted to ask, or maybe you can clarify, because our group also had an issue related to this ongoing and self-mitigating and restoration, and I'm not sure if that's this issue or that's an upcoming slide that you haven't got to yet.
Better ask it now.
So I think last Friday when we were here, we talked about that in some of our situations, particularly with our artificial constructed facilities, when we do O&M, sometimes when we will do on-site restoration or it's self-mitigating. And so we had talked about maybe having some language to address that. I think we have provided some language. And so I'm just not sure that this is getting there or it's coming in. Maybe I'm going to see if Jeremy or Marilyn can fill in for me here.
So I totally understand. Before you fill in, because I remember the conversation, and I thought that we had a different area that we talked about that. And so I'm going to have staff at lunch find that and see if it's in the slides or if it's if it got skipped. But I totally understand what you're saying. It's the idea that there are sometimes when it's when the actual restoration occurs because you've after the mitigation or maintenance that just occurs. It's a self-regenerating mitigation restoration. I should say not mitigation, restoration.
Yeah, I think it is a different issue and it applies to a different section of the permit. If I'm not mistaken, Paul, is this applying to section 2? Let's see what it is on the renumbered. Roman 2, 3C. Okay, and so we didn't ask for clarification on Roman 2, 3C, but we did ask for clarification on temporary impacts of O&M.
Okay. All right, this issue is related to where in the process do the permit procedure, the procedures apply. What we had proposed in the staff was that there would be a 6-month period before they came into effect, and then any application that isn't approved by that point would fall under the requirements of this. I believe that what this request is to have applications that are somewhere in the process have it apply, because these take a long time and 6 months might not be enough time. So we heard suggestions about substantially complete, something like that. We don't at this point have any language on that, but we have heard people's concern. We thought we were addressing it with 6 months, and we've heard that that might not be enough. I don't know if there's anyone else that wants to comment on that.
We appreciate your considering that, and it often does take considerably longer than 6 months to get applications complete with some of the regional boards. We did offer some language on this in the red line we sent up Monday night, and the idea would be, as I recall the language, it was somewhat along the lines of if they submitted an application and made a good faith effort to respond to any incomplete letter that's been sent to by the regional board back, then they're grandfathered, provided they get complete within 180 days after the effective date. So a little bit of room on both ends.
Sure. All right. I am going to suggest we have take a lunch break at this point, and that we get back here at 1:15. Thank you all. All right, folks, I think we're going to try and get started again. We have a few less folks, but that's probably understandable after lunch and after this morning, yes. So I wonder why this says that. We'll just see.
It has no input.
So before we jump back in, a couple of things. My understanding is that we were able to print up slides in the back of the room so that people have them. And everyone should jump up and steal them right now before they're all gone. Okay, great. It looks like the folks that wanted it got it. And we'll then, as we get ready to jump back in, I'll just remind folks that we're trying to make sure that we captured the areas of changes to the policy that folks want. And we encourage people to ask questions about it and have a discussion between yourselves if it is warranted. We had a couple of those earlier today, and those were helpful, I think. And so we encourage that. The next group is going to talk about prior converted cropland, and there's a series of slides on that. So don't worry if you didn't see what you proposed immediately. We'll try to get to all of them. So for some reason we don't see it anymore, but that's okay. We've got a printed copy. Hopefully we'll be able to follow along with that. So as we touched on earlier today, we had a streamlined version of prior converted cropland talking about qualifies, and this is another approach that adds in trying to capture the abandonment to language that we had, and so we wanted to make sure that we showed the different approaches and different types. And as I said earlier, we're still trying to refine how best to deal with this. But I believe that that this is primarily to capture the 5 year of non-use in the abandonment. And do you want to?
Yeah. And another distinction. So in addition to explicitly referring to abandonment, the other difference between this language and what's in the staff proposal is, as I understand it, Clark, the idea would be to delete the last sentence, which refers to conversion to a non-agricultural use. Is that, I think this was this your option?
I thought it was just in the wrong place.
Oh.
Oh,
So this is.
No. We're saying separate things.
Earlier, you raised a formatting issue with what we proposed, so that we lost a numbering on FERC, but I think Phil is flagging this option eliminates the conversion to non-agricultural use.
I see. This option 1 eliminates the conversion piece, and it has a shorter definition of abandonment. Okay.
That's correct. That's the best way to say it. Thank you. Yeah. Uh-huh.
Waters of the U.S. intersect, that this is being applied. So it wouldn't apply to just waters of the state is the question. To just waters of the state is, because you're referring in II to certification by NRCS, the Corps, or EPA, and if it's just a water of the state, then I guess it would fall to the permittee, the regional boards then to make the call. Is that what you're saying with this language?
So, Tess, did you want to jump in there? You seem to be able to explain it better than I do.
So just for clarification, this is to be excluded from the dredge and fill procedures. Under the current waters of the U.S. definition, prior converted cropland isn't even a water of the U.S., so they don't need exclusion from the dredge and fill. But under this policy, while they may not be a water of the U.S., they could be a water of the state under the new definition for water of the state. So this, as I understand it, would exclude us from the state's dredge and fill procedures for that prior converted cropland, but otherwise isn't subject to it on the federal side at all.
And you know the conservation group's stance on this, so I won't reiterate it. Well, I don't know that we're supposed to be talking about why we would oppose such language, so.
But you could.
Our concern is that PCC is a policy construct. It has nothing to do with how NRCS defines wetlands. If you look at NRCS's wetland definition, it's very similar to that of the Corps and EPA, but for the purposes of Swamp Buster, to try and discourage elimination or conversion of wetlands, they've got this other category, they call it PC, that exempts ongoing ag from regulation under 4.4 as long as NRCS or the Corps or EPA agree that it is a PC area. And our concern is that there are areas that we've come across in the Bay Area that could be labeled PC because they don't have the proper hydrology. And in that, I mean, they don't pond water, but they could be saturated to the surface, and yet they won't, they could conceivably be exempt from regulation under the Clean Water Act. And in one of the sites that we've provided to the Water Board staff, it actually is a wetland area that supports endangered species. So we're concerned that we might miss areas that have wetland functions and values, albeit they may be reduced because of altered hydrology. They still provide some wetland functions and values that we wouldn't want to see removed from any regulation.
I guess I'm maybe a little confused as to what you're saying. The point of exempting prior converted cropland is that it is wetland features that you're exempting that have arisen on an area that completely eliminated whatever original wetlands were there before 1985 and essentially residual from the agricultural activity. So it is wetlands that would be excluded and are under federal laws. I may be missing a point, though.
Our point is that there are areas that may meet the qualifications of PC that have been cropped but still have retained their wetland features. The site I'm referring to has had wetland features as far back as the beginning of the Clean Water Act, and it was farmed, but it has continued to retain those wetland features to the point where if it isn't drained, pumped, if water isn't pumped off, then it will reestablish thriving habitat for endangered species. So I think, and I think this is a real muddy area in the way that the whole PC thing has been written up, and the board is trying to navigate this through that, and I appreciate they're doing that, but what we're saying is that not all PC areas are areas where wetlands have come back, but they're in fact areas where wetlands have persisted despite alteration of hydrology.
I don't think that's correct. A PC is an area where there may have been wetlands that were entirely converted prior to 1985. That's why they call them prior converted. And if wetland features emerge on prior converted cropland, as long as the land hasn't been abandoned, it's those very wetlands that you are allowed to affect or fill under. That's the whole point of the PC concept. This is, I know Dee Dee wanted us to identify our priorities for the Ag Coalition. This is a top priority, just so people know.
So I think that when we go to the next slide, I think this, if my understanding would reflect your position that, that under our procedures, we shouldn't include an exemption from state waters for prior converted cropland. Yes, this is not on 404F.
If it meets the state's definitions of wetlands.
Right.
I'm sorry, 404F does not cover situations where you might want to fill prior converted cropland. They're not, they don't overlap.
No, I might not be getting it quite right, but I'll try, is that I think that what you're asking for is that that the prior converted cropland exemption that is available for waters of the U.S. would not be available for waters of the state. That doesn't preclude the 404F issues. It's not. They're not saying that that normal farming activity would be excluded. I'm trying to distinguish the two. Yes, Tess.
I think that I just want to remark that I think you need to be careful that what you may end up then doing is disincentivizing farmers from, on an occasion, having good habitat on their property, because you're going to encourage completely clean farming. We have voluntary settlement agreements that are being worked on that will basically require farmers in Northern California to fallow land so water can be transferred to meet environmental purposes. If we fallow that land and the wetland feature comes back the next year or 2 years later when I want to farm it, if you take this exclusion away, I need a dredge and fill permit now to go back to my farming because I've let it go for 2 years to fallow to meet voluntary settlement agreements for the benefit of the environment. And now I'm into this scenario. I don't think that's what you want to do. I don't think you want to discourage us from doing that and making water available for environmental purposes.
It is 5 years according to the regs, and we're not trying to adversely impact the agriculture or disincentivize protection of wetlands or conversion to wetland functions and values. But we've encountered the opposite, where the PC exemption is used to land level land until it no longer retains any wetland features at all, and then go in and get a disclaimer for the Corps so you can put in a housing development. And so that's the kind of thing we're trying to avoid. If there's a way that we can come to some agreement or some language to avoid that situation, we're all, we're open to it. But right now, that is something, I mean, we actually had people being advised to go out and land level, get their PC land level, and then apply for a land use change. So how do we avoid that situation and still protect waters as state, protect ag, and protect, wetland restoration as our concern?
Well, I think theoretically the way you do it is you leave the PCC exclusion in the procedures, and we're not endorsing this. You simply say that conversion to non-agricultural uses is regulated. Now, we're objecting that from a policy perspective, but that's how you get at the problem of, using PCC to get at home builders. But you shouldn't throw the baby out with the bathwater. PCC is very, is very important to the agricultural community.
Okay, thank you. I really appreciate the dialogue. It really helps
I just want to add in, I'd be more than happy to have that conversation because I am not here for builders. I'm here for ag and ag only. So whatever we can do to make that happen.
So we've got a third one, and I'm going to turn this over to someone else because I don't really understand the difference now.
Okay, there are a couple of different options for PC. One was removing it entirely, and I think we've discussed that. Another option proposed by some of our environmental stakeholders was to more closely match the language that was in the 2016 version of the procedures. So restoring a definition of agricultural commodity and abandoned, and retaining the language. I think the primary difference between this and the 2016 language is just a small change to the wording of the PCC exclusion will no longer apply if the PCC is abandoned, and this is where the change is, or proposed for conversion to any other use other than the production of an agricultural commodity.
So I want to weigh in just with a little bit more detail on this. This option does provide a couple of definitions of what some of those terms mean. Specifically, agricultural commodity would mean, in this case, crop planted or produced for annual tilling of the soil. That would be a more limited form of agriculture than what is. It doesn't cover the full breadth of agriculture that's out there. And it would also say that abandoned means PCC is not planted to an agricultural commodity, which means movement from an agricultural commodity, these crops that are annually tilled, to some other type of cropping. Again, I'm going to throw out almond orchards. That would trigger an abandonment clause.
So this is our attempt to try and protect the interests of ag and hopefully the interests of conversions for wetlands, wetland restoration projects, and still prevent conversion to a non-agricultural use. This was our attempt to find the middle ground.
And I appreciate that. I think the problem that, and I was the one who has major concern by using the term agricultural commodity, it has a specific meaning in the federal, Food Securities Act. And so it does not apply to all of agricultural type crops within California. So it is much narrower than maybe you intended it to be. And while we're not saying that it's being defined here that way, I think, as any lawyer, with a regulation that's so heavily tied to federal law, if there's a challenge, it goes to court. A court is going to go and pull out that federal definition of agricultural commodity to determine what this term means. So that was kind of my concern, that this is far narrower than I think maybe folks realize when they use the term agricultural commodity.
All right.
So just to follow up on that, Tess, I mean, this actually includes a specific definition for that phrase, agricultural commodity. Do you think the ag community would have a concern if it were truly limited to just this definition?
Now, I'd have to talk to some of the permanent crop folks, but when you go into annual tilling, when you get into trees and permanent crops, do they fall within that annual tilling component that you have within here?
I think our assumption is that they do not. That's what Paul mentioned, orchards, for example.
All right.
Yeah, I don't want to hide the ball on this. We chose agricultural commodity very deliberately because one of the things that we're seeing right now is a changeover from annual cropping or rangeland to orchards, which is then used as a precursor for housing development, because you're then altering the features of the landscape so significantly that you're eliminating all wetland feature to the landscape. So that is, so yeah, you're right. And, not trying to be coy about it, and just that was our option. We feel like this is a good middle ground compared to the, us preferring to have the exemption completely eliminated. This would be sort of, split the baby kind of thing.
And I appreciate that. What I'm hearing is that would be a major concern to folks about that. But I'm not having a opinion one way or another. I'm just trying to hear what people are saying. Okay. You said there was going to be another?
Yeah, the next one.
That I didn't see.
Now, I don't know if this is on the printed versions. It probably is, but it's not. Well, we added it this morning, but maybe it didn't make the version that got printed. So this is actually, I think, a relatively simple change to explain. And it's really about the same concept, just rewording the concept for a timing issue. So the version that went out to the public and the board was looking at from January 3rd included this language that now has shown up as being stricken, which is that the prior converted cropland exclusion will no longer apply if the wetland area changes to a non-agricultural use. It was pointed out to us that by the time it changes to a non-agricultural use, if that's what we really mean, then of course the PCC exclusion doesn't apply, but it also hasn't done anything with respect to essentially protecting the wetlands up until the point that someone's proposing to change to a non-agricultural use. I'm sure I could say this better. The proposed underlying text, though, makes it more clear that what we're really talking about is if the discharge of dredge or fill material is intended to convert the wetland areas or results in converting the wetland areas to a non-agricultural use, then that discharge would have to go through the procedures. So it may be what everybody thought the language meant in the first place, but somebody pointed out to us that the way we wrote it, it's a little bit less than perfectly clear that we really are trying to apply this conversion approach before it's converted to a non-agricultural use, and recognizing full well that some folks would prefer that we not use conversion as a basis for losing the PCC exclusion.
This sounds to me like really a clarification of intent. This is the way I had been reading it based on our prior discussions. Obviously, we object to it, but
I appreciate
seems like
that. It's actually the way we were reading it too, until somebody pointed out that it could be read as a sort of closing the barn door after the horses left.
All right.
So one question that has come up when we're looking at what you guys are proposing for prior converted cropland, and that is, so there's areas that have been identified as prior converted cropland by NRCS. And then there's a definition of prior converted cropland as it applies to federal jurisdictional waters. But so I guess where I'm going with this is what's your standard for determining what is prior converted cropland for each party that comes in and makes the claim that their property is prior converted cropland? Is it mapping? Is it a receipt for seed? Is it, like, what is it? Because to me, it seems like you're opening the door to, I don't know what, for the regional boards. It'll just be, frankly, I think probably a big argument. So I'm not that I think that, you know what our position is on the prior converted cropland, but if you're going to go down the path of this issue, I mean, it seemed like you might want to give some guidance.
I think there may be two questions embedded there. First, what's the standard for qualifying as prior converted croplands? And then second, how does somebody actually prove that they meet that standard? So the standard is generally, prior to 1985, that the land has to have been cropped. There's a lot more to it, but I think that's not really your question. Your question is more the second step, which is how do you prove it? So it's a good question. The language that we have here that we're proposing anyway, and it came up this morning, is that the applicant may establish that the area is prior converted cropland by providing relevant documentary evidence or a current prior converted cropland certification by a federal agency. So two things there. One is essentially we're putting the burden on the applicant because they will clearly have a better opportunity to have access to the information than we would. But we're being flexible in terms of what that documentary evidence would look like. Certainly one expectation is aerial photographs showing that the land was actually farmed prior to 1985. But there may be other things that we're not clear on what they could be. So we're not saying it has to be aerial photographs, for example. We're trying to leave it open. Maybe some folks might have some ideas about what we should expect to receive. I don't actually know what they would be.
I guess my response would be that providing evidence of a PC qualification is really just part of the delineation process. The regional boards are going to be out there delineating waters of the state, and PC is just part of that. And when you're doing delineation, they're often going back and looking at historical old aerials. Another example is an area that's wet but would revert to dry land if irrigation ceased. That's sort of the same thing. So I don't see that demonstrating PC status is really much different from just doing delineation. Be the same kind of evidence.
But it would have to be of a historical nature, right?
Yeah, and delineations often are of historical nature. Historical aerials are a common part of the delineation process.
All right, so I'm going to, as you can see, we have a lot of things on PCC that are not yet totally clarified, but we're working on it. We're going to continue to try and work through this. And I'm going to move on to this, I think, is also somewhat related, and I'm going to let our legal people explain where this goes and what it means.
Go for it.
The next slide shows a proposed new procedural exclusion for non-tidal drainage and irrigation ditches. I'm going to let you just read the slide to let people know where the source information from. This is largely from the 1986 preamble proposing the definition of waters of the U.S. So it is, we would like to get input on this though, because it's new language.
The reason this is important is under the 404F exemption, that exemption under federal law doesn't apply if you're reducing the reach of waters or impairing existing, well, I forget the exact magic language. And so in an agricultural landscape, you're going to have these various types of features that may look like waters of the state. And you couldn't do anything with them under the 404F exclusion because you're not allowed to affect waters, say by building new berm or something like that. And so these exemptions are a way of allowing ordinary farming activities to occur that might unnecessarily in the clawback under 404F. And that's the way it's been worked for quite some time.
And it does seem to be restricted to dry land areas and not, so that wouldn't be.
It's really intended to get areas that used to be dry land, but because they've been used for agricultural purposes, they got wet. And under federal law, they're just not waters of the U.S. ordinarily. But we have no problem, at least my group, having this as a procedural exclusion.
All right. Yeah.
So I haven't seen this language before, so I'm just looking at it. So I'm assuming this, by talking about it being dry land, it would be that they're essentially saying that land that was never a water of the state totally dry, no parameters, but you added water to it. Either it became an irrigation canal or stock pond. I don't know how rice growing honestly would happen on 100%. But anyways, point being is that it never historically ever was wetland. And thus, whatever you do to add water to it, it'll still never become a wetland under the definition of waters. I'm just trying to understand what they're.
So this language is a quote from the preamble to the Federal Register publishing the 1986 regulations. The intent of the language is not to, it has to do with agricultural operations creating features on land that is at that time dry. This doesn't go back to the historic footnote 2 issues. It's if you build something on dry land and it basically turns wet because that's the very nature of the feature, then it should be excluded from the procedures because it's part of the agricultural operation, and it may not be protected by 404F. And so 404F and these exclusions operate hand in hand, basically, in an agricultural setting.
So I think, let me know if you think this is a fair characterization. So the language is what it is. The proposal is based on existing language so that people are familiar with it. But I think you're keying into a question that there is not a clear answer to. What does dry land mean? And I think there was an attempt to look at the 2015 Clean Water Rule, which added some contours to what dry land is, but I don't think that's fully satisfactory to anyone in conclusively answering the question on what dry land is. So that is an ambiguity with the proposal. Is that a fair assessment?
Well, I think the way it's applied by the federal government, dry land means not a water of the U.S. It's typically the way it.
I think there will be disagreement. Is that fair? Okay.
Can I just ask the question, when you say to retain water, is that artificially introduced water, or could that be water that's sheet flow, overland flow? Did you have a specific idea of what you meant by?
Well, a dike would be capturing storm or sheet flow. That's what a dike does.
Okay. Thank you. We're going to move on to the next one. All right. So this is directly related to the cultivation of rice. And it was pointed out to us that a rice field in production meets all the definitions of a wetland, a water of the state. And under our procedures, it would then become a water of the state just in its activity. And as such, it's conceivable that all basin plan requirements for waters of the state would apply. The example is it would need to meet municipal water supply because it's a water of the state. And that would not be compatible with its function as a cultivation of rice. And so we're trying to figure out a methodology for addressing that. We had hoped to have two options to discuss today. And we have the description of the second option, but we have not come up with actually a way to do it yet. The first is essentially to say, the way I understand is that while it's in rice production, it would not be a water of the state. And then we wouldn't have the need to address the issue of how do we deal with basin plan objectives, the state policy that all waters of the state are are assumed to be municipal drinking water supply, those kind of things. You wouldn't need to get a permit for planting or for adding nutrients, those kinds of things. The second option would be to write a procedure exclusion that says, yeah, it's a water of the state because it meets all those functions, but we're not going to apply those requirements to it. We have had difficulty writing that, and so that's why we don't have anything yet. We're hoping to write something that would describe that, but I'm not sure we can get there. I think that's is that a fair characterization, Tess?
So personally, I think option one is brilliantly written, and you should just take it as is. But with respect to option two, I think it's just important to clarify that I don't want people to think that your option two is suggesting that discharges from rice fields are not subject to waste discharge requirements. They are, right? Where they are subject to irrigated lands orders. What we're really talking about is that discharges into the field, not from the field, would not be subject to waste discharge requirement procedures. So I just want to clarify, because I don't think the way you have option two written could be taken the other way. And I think, as I've shared with staff, that option two to me raises a lot of potential problems and ambiguity, and based upon some case law that does exist, I'm not even sure how we can get to option two to providing, comfort with respect to that nothing in the future as far as going into the field isn't going to have beneficial uses.
Yeah, and so obviously we have some of the same issues because we weren't able to over the weekend come up with that approach. We're still looking at it, but we understand your concern. I did want to say that I didn't mention that we consider under cultivation includes those times a year when it's flooded for bird fowl and things like waterfowl and things like that. It's not meant to be just at the time that the rice is being grown, but that it's under cultivation for that period of time. I also don't find this, even though we have it in this policy section because we're trying to figure out the best way to do it, we don't see this as really controversial. We might be wrong about that, and we'd like to hear if other people do, but.
Yeah. Tess, just a question. Do you know, does the Corps ever treat rice fields in any circumstance as waters of the U.S.?
I actually, in looking, I think that may be all over the map, because I actually, in reading some of the 93 preamble I was doing over lunch, there's another whole section of the federal side which talks about farmed wetlands versus prior converted croplands, because prior converted croplands have an inundation requirement that rice fields probably don't qualify for, and they then fall within the farmed wetland category. So I got to dig in a little bit deeper on some of that to kind of figure that out.
All right. All right. So I'm going to let somebody else jump in on this one. I don't remember this one being discussed. It probably was, and I just don't remember.
I think this is actually not dissimilar from the sentence we discussed this morning, where we were talking about, and this was a sentence that I think got 0 votes in favor of, including from this table probably, which was to explain that historically or currently the water boards generally do not regulate discharges of dredge or fill material that are associated with agricultural activities under 404F or prior converted croplands, and just recognizing that's the status quo, and before a regional board, if they were so inclined to start regulating them, that they would need to notify the state board. This takes it, the same concept, but a different twist on it, which would essentially just not allow the regional boards to regulate those discharges. I think that's what the intent was, but I should double check. Clark, did I get it right?
So now I now recognize it. I'm sorry, I didn't recognize it before. Is that this is that same issue. It's we had attempted to deal with it earlier today and felt like that was the best we could do based on this issue of excluding a discharge. So let me say it another way, because I'm getting a lot of blank stares, is that this policy and procedures is meant to address the procedures used to regulate dredge and fill material. We have a statement at the beginning of the document that that Phil will find the citation. I know he's doing that right now. That says that doesn't preclude the regional boards from addressing issuing waste discharge requirements. And we were asked, well, we should put in something about that to say, yeah, but we're not going to do that for dredge and fill material. And it is our you know, the reason that we're doing this document is to describe dredge and fill procedures. But when we put that in, what I understand from our legal attorneys is that is a exclusion, a waiver of waste discharge requirements, and require us to do a 5-year plan. And so, is that correct?
Yeah, that's pretty close. All right, so, and I don't know which versions people have in front of them, but we're talking about lines 443 to 445 in the version that I believe we handed out this morning. 443 to 445. So this explains that the activities and areas under section 4D, that they are, that although they're excluded from having to submit an application under these procedures, what it says is that those exclusions do not, however, affect the Water Board's authority to issue or waive waste discharge requirements or take other actions for those same activities or areas. So we're saying you don't have to, for dredge or fill, you don't have to follow these application procedures, and the water boards don't regulate in accordance with these procedures, but we are preserving the opportunity for the water boards to regulate those same activities to the extent that the water code allows them to. So this would be, what's on the slide here, what's on the slide here would essentially, we would take out or modify that lines 443 to 445 and say that if the areas and activities are excluded from the procedures, then the water boards will not regulate those discharges of dredge or fill material.
I agree with staff's assessment that the language provided this morning still needs a little bit of work. I think we all understand each other's intent. Got to figure out how to get there. Obviously, I really like this formulation, but I don't think that's what anybody really intends. So we might need to just trade some language on this, because it's been a little bit hard to nail down, but we appreciate your willingness to try to do that.
And we're going to keep trying. I don't know how to get there at this point. So we were asked to include language that would clarify that that dredge or fill materials may not, in all cases, be a waste. I think that is true. You have different material they discharge to dry land, it's not a waste. Yeah, so this, I'll just use the example that is easiest for me to understand, and I think there are others, so don't take it as this is the only thing. But you take a material that if it was discharged into waters of the state would be considered fill, and you discharge it onto dry land, it is not fill. And we were asked to clarify because in the aggregate mining terms, that's a product, not a waste, and they don't want it to be construed that it's a waste. Any other?
Yeah, no, that's essentially right. I mean, I think I mentioned this morning, the water boards have authority over discharges of waste that could affect the quality of waters of the state. So something that could be a waste that could affect the quality of waters of the state in a different setting would not be a waste that could affect the quality of waters of the state. And I think, Adam, I think you had a good suggestion. I mean, there are many places where aggregate could be located where even with stormwater runoff, et cetera, it could not affect the quality of waters of the state. But on the other hand, if you put it into a water or right next to a water, it certainly could. So it just really does kind of, I think, it's an attempt to try to explain that maybe depending on the context or depending on the circumstance, not all materials are waste that could affect the quality of waters of the state. Is that fair?
Yeah, I think there's a general disagreement that the material is waste as well. I think there's a general disagreement that materials that are fill are waste as well, that has been encapsulated in previous comments that go back to the historic record, the statement from that. But yeah, when you look at what the world of fill materials are, if you look at the world of fill materials as defined in federal statute, you say, it's essentially anything that can out of the stream that's applied to water. It's not fill. I mean, it could be, structural features, concrete, steel beams for piers, et cetera. It can be anything. And there seems to be a blurring of the line. And we were just thinking about the whole, if you create confusion about fill, if you create the confusion about fill for water boards, we end up in a lot more debates about what our product, valuable construction materials being construed as waste. And that's of concern. We know we're subject to stormwater permits. We know we're subject to other waste orders for waste materials for, and processing activities, et cetera. But it seems to be a big blurring that is coming across by calling fill materials waste.
And so we've got that down. We're trying to, as you can see, we don't have any language yet to figure that out. And Clark is going to help us out right now.
Well, not as much as you might think. Once you get good language, a nice place to put it would be footnote 15, where you already have a similar concept expressed with respect to discharges, and this would seem to be a natural extension of what you have in 15. Very related. Yeah.
All right. I think we're going to move on to the modification. I'm going to let someone else take these. I didn't see these.
Oh, yeah. Jeremy still here? Jeremy, here you are. Here's your item. So, so Jeremy has brought up several times that he doesn't want to see construction of a diversion structure to constitute a modification of water to the state. That's something that we're trying to figure out if there's a clarification there that we could put in the jurisdictional framework portion that says modified water of the state. I think that's consistent with what we intended. Diversion structures are a separate thing. There is another option, which is we could put a date range on what it means to be modified. One particular idea is anything modified after or before, Phil, did we capture that right? Yeah, anything modified after 1949, which would be the passage of the Dickey Act. Another one that was thrown out was 1969, which was the advent of Port of Cologne. Yeah. So those are a couple of options that we're taking a look at. Love to hear if you guys have some thoughts about that.
There you go.
How's this?
Wow.
I only said 2 words, so we'll see if it lasts. Okay, so could you go back to the previous slide so I could look at the 2 options there? So option 2, I haven't really thought about that, but I'm not sure that really works. This change here is very, very simple. It is only to clarify that, and this deals what we've called a clawback provision. You can call it something else. You can call it an exemption to the exclusion. The idea being that if there's a modification of a water of the state to create this artificial wetland and upland, that it would thereby become a water of the state. And so the footnote that's there, I think, is helpful, but I think what would be further helpful in clarifying the intent is that in order to make a wetland, you have to have water. So you can get that. You can get that from various places. You can get it from groundwater. Now, the language you put in today about surface water is helpful in that regard. But oftentimes where it comes from is, diversion off of a stream or wherever. And so that diversion itself, now that may require a water rights permit, that's a different issue, but it shouldn't be something that transforms what would otherwise be a wet upland into a water of the state just by virtue of the fact you had divert water off a stream, because that's going to be the case in almost every example where you have groundwater recharge. You're taking surface water and you're getting it in the ground. So that's the reason for that.
So I think that this doesn't say it very well, but if I could paraphrase and make sure I've got it right so that when we're working on it, we've got it right, is that the act of diverting water to a area that would otherwise be a non-water of the state that creates a water of the state doesn't make it a water of the state.
Yeah, except that I think you put one too many waters in there, but I understand what you meant. Yes, and so, I think you're on it, Jonathan.
Okay, so we'll refine this. Yeah, but I do want to clarify, and I think you said it, but is that the actual diversion structure itself in a water of the state or the water of the U.S. would have to follow the permits for constructing that.
Understood. No, okay. I get that. I'm not. If it's already in the water state, they have to follow the rules that apply. But the water they then goes to the other. I think we're on the same sheet.
This is a test of.
I got it. This is brand new. I've not seen this before, and we're still trying to figure out if we're going to be okay with this or not. There's some concerns that are being raised, and so I just want to note for the record that we'll respond, but this, don't know everything about everything sitting here, so.
Sure, no, we're in the same situation, and we're happy to talk about that. I think once we've discussed our situation, my hunch is you'll probably be okay with it, but we certainly want to make sure you understand what we're thinking about, and that, when you ever talk about diversions, I understand how people get nervous about that, but I think once we talk about it, you'll be okay, but we'll make sure of that.
Yeah, that would be really helpful, because it seems to me pretty broad right now, the way it's written. So.
Yeah, I should point that this is in context to, we have a description of that these kind of features, and they, that we spell them out. I'm sorry, I'll find if you could find the place where we talk about wastewater ponds and industrial ponds and recharge in upland or that are not located in waters of the state are excluded. And the concern here was, well, if you divert water from a water of the state to create that, would that suddenly turn it into a water of the state?
Right.
And so what we were trying to do was explain that these exclusions would still apply even if you were taking the source water from water of the state. And I know that most of these don't, but we added a surface water treatment and recharge to our we're proposing to do that because there are instances where that is part of the TMDL or a treatment option for improving water quality. So I'm not trying to convince you, I'm just trying to tell you how the context works.
Okay, well.
Is it clear where we are when we talk about modify?
I think that's what we're trying to figure out.
So in the jurisdictional framework, so section 2, the new number 2, it says wetlands created by modification of a surface water of the state. And I think their concern is if I divert water off a stream, does that constitute a modification?
Right. The stream itself would remain jurisdictional, but in order to be able to create either it's a recharge facility, whatever it is, an artificial wetland, I have to have water. So without this clarification, arguably everything listed on that list of 10 items, they would, because they all are diversion from something, most of which are waters of the state, it would largely render the 10 items on the list largely meaningless unless it's clear that diverting from water of the state doesn't constitute a modification.
If I could try one other formulation just to make sure I'm understanding your point.
I made it worse, maybe.
No, tell me if this is another way of saying what you're worried about.
Sure.
That the act of diverting water from one waters of the state is not the type of modification of a waters of the state that all by itself would result in the creation of a new water of the state.
That's correct. Yeah,
and I understand your issue. I have to say, I do think the rest of footnote 2, now 3, covers it, but we could probably do better. So we'll look at if there's a way to make that footnote even more clear.
Okay. Yeah, we provided specific language on that. We'd be happy to share that with folks and defenders and see if we're on the same sheet.
I believe Daniel Kozad has also reached out to you guys so we could talk about this.
I think we're going to talk to him next week.
Perfect. So
Okay.
we'll look at the language in that.
All right, we'll figure it out. Thanks.
Just to be clear, the second option, and whoever said it was correct, this doesn't, I think, Jeremy, this doesn't really get to your issue at all. This was suggested by one of the stakeholders as a way to sort of help implement the idea, and the concern was that as written, if a water of the state is directly converted to one of these features, that is, it's somehow modified, it could have happened over 100 years ago, and it would be very hard to know exactly what was there before the current feature, immediately preceding that current feature. And so the suggestion was, well, if we at least put a time frame on it, and the two ideas, like Paul said, were either when waters of the state first became a definition in 1949, or maybe in 1969, that at least there were some aerial photographs available from that time period, and so it wouldn't be a huge burden to try to figure out what was there before, immediately before what's there now. That's the idea behind option number 2, just to be clear on that.
Well, mainly I just wanted to ask you exactly how this would fit into the language in what is now 2.3, because I think it's a very interesting idea for that purpose, but we didn't suggest it. So I'd love to figure that out, because that may be very useful for some of the issues we did discuss with you all last Friday.
Sure. So it was a different stakeholder who suggested it. And I believe I haven't tried to insert it, but I think it would go right into number 2, wetlands created by modification of the surface water of the state on or after 1949. something along those lines.
Yeah. It also could be useful for the other issue that historic or current waters of the state, right? So under any definition, and that got worked in, you changed it in this version before it was like number 3. If it was ever a historic or current water of the state or water of the U.S., then it wouldn't qualify as, it would be a water of the state, notwithstanding that otherwise an upland, right? So the concern for our side's been, well, pretty much anything that's wet as grass could have a migratory bird in it, and that's always been the concern. And so to the extent you added a time, and I don't know if you can, but that option 2 might actually address that if you set up a certain time where after X date.
So I would just offer that we view the wetlands created by a modification of a surface water of the state as separate from whether or not it meets a definition of waters of the U.S. The language is actually different. We're not proposing modification of a current or historic water of the state. It's just directly from a water of the state to whatever's there now.
Okay, okay, thanks.
All right. Home stretch, since I think this is the last slide I have. And Mary Lynn, oh, you're hiding there.
Hi.
I think this is trying to get at what you talked about earlier this morning, which is, we had discussed different ways of addressing certain features by putting them in different tiers or having clarifying that operation and maintenance would be the activities. I think that this would be just exclude these features from a water of the state, even if they were directly converted. Is that correct, folks?
Somewhat, yeah. So let me just clarify a little bit, because I think you understand it, but the slide may miscommunicate what we're asking for, based on all of our limited time for prep. So what we've been asking for since 2017 is for existing water-dependent facilities that are naturalized and are created to have habitat, but that are managed and maintained for the purposes in that section to what used to be 2.4D. Now I think that's 2.3D in this current red line. So we're talking about recharge facilities. We're talking about water supply, related to recharge facilities. We're talking about treatment wetlands for surface waters, as you noted, and for stormwater. We're talking about those kinds of water agency, stormwater agency facilities. And for those kind of facilities, our proposal is that the O&M for those should be excluded only from section Roman 4A and Roman 4B. We're not saying they should be just excluded from Porter Cologne or the definition of waters of the state. That would continue to apply. The Clean Water Act would continue to apply. The 401 CERT federal and state regulations would continue to apply, but they'd just be excluded from the procedures. And we've based this request on the fact that most of these O&M activities are consistent. They happen in accordance with plans that are already highly vetted. The nature of the impacts is temporary and de minimis. And when taken in the typically there's a restoration plan always involved. And when taken in the context with the improvement to aquatic function and beneficial use that's associated with this naturalized facility itself, then we feel like an exclusion from A and B is warranted. And that's particularly true because the O&M that's going on is really a public health and safety function. We're not trying to exclude development from A and B. We're trying to exclude maintenance of flood control facilities, taking out debris out of debris basins, taking accumulated fines out of recharge basins so that they recharge. These are the kinds of things that are covered by the current exemption in section 4D1C. And our request here is that we eliminate clawbacks in 4D1C, namely that last sentence that says this exclusion does not apply to discharge of dredge or fill material to a water of the U.S., a water specifically identified in a water quality control plan, or a water created by a modification of water of the state. That is for the purpose that, you know, these are really designed to emulate and to become waters of the state, but they have to be managed long-term. So that's sort of the concept that we're getting here, and the reasoning behind that concept. We understand that staff's proposal has been to streamline via Tier 2 the alternatives analysis. But, you know, we have multiple examples that we're, you know, able to share if more practical examples are useful of situations where even delay and burdens associated with the alternatives analysis can prevent a health and maintenance type of activity from occurring in a timely way as necessary to protect safety. So that's the kind of situation we're trying to address.
And we actually have someone to speak on those issues from Monterey County.
Yeah, thanks. Mark Strudley, actually Santa Cruz County Flood Control, it's quite all right, next door neighbors. We have an Army Corps flood control facility on the Pajaro River, built in 1949, that we're required to maintain conveyance standards for. Over the years since that project was built, it became over the years, the permitting process made it increasingly difficult and burdensome to acquire permits for that maintenance activity in that flood control facility. To such an extent that the time it was taking around the early 90s was such that it put us in the position during March of 1995 where maintenance had not been completed at that point, permits had not been secured, and the levees were breached. The levees broke in 1995. Town of Pajaro was completely submerged and 2 people died. Case law places us in a very precarious position, as well as all of the other flood control districts and agencies around the state. What came from that event was James Ariel v. Monterey County, in which both counties, Caltrans, and the city of Watsonville were sued and we lost, and we continue to pay damages that were ascribed from that case. And the basic message from that case was that there is no excuse to delaying any maintenance in flood control facilities, including securing permits. And so the proposed regulations here adding further burden and requirements to secure permits for operations and maintenance activities would delay that acquisition of a permit even more. And that's why we're so incredibly concerned about these proposed regulations as they pertain to O&M of flood control facilities.
So I just wanted to flag and say that I think that I understand the way it's been explained, and what they're proposing, it appears reasonable. We would like to see the language, and we will have the conversation with these folks, I guess, next week. But it seems like this is one of those places where I think we the NGO community certainly would be very happy to try to, it seems like there could be a meeting of the minds, and so wanted to flag that for you. Just we haven't seen the language, so it's hard to respond.
Okay, thank you. That's really helpful. I did have a question, maybe for Mary Lynn. It sounds like these would all be operation and maintenance activities conducted by governmental entities. Is that fair?
Private water, I mean, I would say probably 95% of the time, yes, but you could have, a PUC regulated entity could be doing similar things, or you could have so on the water agency side, yeah, I mean, you could have it. I guess on the flood control side, that's almost exclusively to be public agencies.
Yeah, so I would say it's a public entity or a state-regulated utility. That would be the universe of folks.
I'm very glad. I think that if you guys can chat, it would be helpful. We've had the discussion, and I wanted to make sure everybody heard it, that, we all acknowledge that that flood control facilities that happen in waters of the U.S. have to follow the Army Corps' requirements, and that this isn't going to change that. And I just wanted to make sure that we've talked about this many times, but I hadn't talked, because you hadn't talked about it. I just wanted to make sure that we weren't hiding the ball in any way.
Right, and that's right, and we appreciate the outreach, and I guess, what we're trying to do, in our role, we actually create waters, but we have to maintain them, and we like to permit new ones, because that helps too, and we'd like to have a way to do that also that will allow that, and we've talked about that in the context of, stormwater BPs, for example.
And we appreciate that, and we really do appreciate the help on moving forward. So, as far as I know, that's the last of the procedural issues that we had identified. That doesn't mean we didn't miss some. And so this is the opportunity for folks to tell us, we tried to tell you and you weren't listening, or you didn't hear, or you ignored us. It's not because we don't like you. It's so we would like to get any of those at this point, and then we'll have some wrap up.
I think all of our heads are spinning a little bit at this point. My plan would be to go home tonight and look at what we provided and kind of review what happened today. And it's hard for me to think off the spot whether we've missed anything.
I would also, one of the things Mike's going over, to remind folks that think about what's our priorities and potential areas to connect with the NGO community or with other folks to try and address that. And it looks like there's a bunch of things, so we're going to get to them.
Hi, Ellen Weir with Grassland Water District. I apologize that I couldn't be here this morning. I tried to ask that the EREP issues be addressed later, but I understand you went chronologically. We had previously requested some resolution language that acknowledged that managed wetlands in the Central Valley are already regulated as irrigated lands, and that the intention of the policies was not to interfere with the public trust values of those lands. I know there was I heard from my colleagues that there was some good discussion about the restoration plan language, and so I just wanted to circle back, not to reinvent the wheel in issues we've already talked about, but wondering whether those were addressed earlier.
Hi, Ellen. No, actually, we didn't talk about that this morning. And, you and I had a brief email exchange about the concept. But I think the idea that you're identifying in terms of at least recognizing the public trust values, I don't think that's at all a concern for us. I think the only real concern that we have is if we're doing anything that looks like we're trying to sort of grandfather in existing levels of regulation, we would need to be very clear as to what that existing level of regulation is. And that was sort of what I was trying to elicit from you. I don't think I did it particularly well, but so trying to understand better if there's something more specific than recognizing that these features are important. They do really provide these values for the environment. That I think is easy for us to do in a resolution language. It's when we go beyond that I think we need to be a little bit more clear.
Okay, and is there a resolution on acknowledging that managed wetlands are already subject to waste discharge requirements under the irrigated lands program? And so, I mean, our whole point of asking for that language is to recognize that you can't call us both irrigated lands and maintain wetlands and regulate us under both of those provisions, because that kind of doubles up on the programs and fees and other costs.
Sure, I totally understand that, and we will, look at that. My general take, and these folks will have to talk to you about specifics a little bit, the lawyers. My general take is that we have already identified that if your dredge and fill activities are covered under a general order, it might take care of it. The reason I say might is because it was envisioned that would be a general order for dredge and fill. And I know that there's this issue that they included you under the irrigated lands program. And so we just need to figure that out. I also know that many folks have asked to get out of the irrigated lands program because, and I agree that doesn't seem to be quite the right place. And so I agree that we need to figure that out. And I would love to have you and Phil talk a little bit more to see if we can get a better clarification.
Just a placeholder for a couple things we haven't discussed today at length, but I noted before that we'll want to talk to you more, and the degree to which we need to talk to you more is really directly related to the fate of this exemption in 4D1C. But we do have some, again, depending on the fate of that particular exclusion, we do have some additional language proposed that would deal with the application of these procedures to renewals of permits for O&M, and also the requirements for restoration plans for temporary impacts associated with O&M, and particularly differentiation between restoration plans required for temporary impacts versus compensatory mitigation. Again, really related to IVD1C, so, but noting placeholder, we may need to come back to you.
Yes, understood. We'll go here and then over there.
Oh, this is just a small one.
Nice, thank you.
And we talked about it earlier. It's about the, it's footnote 8 in the January draft, footnote 9 in the red line, the new red line version. And this is where the state agency is acting as a CEQA lead and party to an existing written agreement, like an MOU. We'd made a request that maybe we would like to see some transparency to that, and we'd requested that maybe there'd be a requirement of a public meeting. Just because otherwise it's hard to track something like that.
So that's in addition to our normal practice of noticing them, but to actually have a meeting. Because just so, and this is not defensive, just telling you that our normal practice is to put them out for notice, and if people raise sufficient concerns, we have a board meeting, and otherwise we don't. And that's been our past practice. I'm not saying that's right or wrong, I'm just letting you know. I'm not very impressed with the roaming mics, just so you know.
My name's Jennifer Gillis. I'm from the Division of Environmental Analysis at Caltrans, and I want to thank the group for this workshop. There have been quite a few items that have come up related to stormwater today, and in our discussions, earlier discussions with you, we have not been representing that group because the procedures haven't been focusing on them. Some of the items you've brought up today definitely would require their involvement and review. And so I wanted to ask, in any conversations you have about these exclusions, can we please include that group? I can work with Paul on who to include. Okay, thank you.
And just to be clear, if we weren't, that these are to facilitate the stormwater, not to pull them into these procedures.
Hi, Jonathan. Catherine from Los Angeles Department of Water and Power. And we're still concerned about having to have a final mitigation plan before the commencement of the project. It's very difficult with the time involved in the administrative and permitting process to have that completely finalized. So we need some relief. And I think this is in Appendix A, Subpart H, page 37.
So I will let them look for the exact language, but my recollection is that the way it's worded now is that you don't have to have a complete mitigation plan, your mitigation plan done for your application to be complete. You just need it done before you actually commence construction, is the way it's worded now, I think. Before you discharge, excuse me. And you would, what you're looking for is the flexibility that that's not, if there's runs into some problem, that could be extended.
That's it.
Okay. I'm thinking about it. I wouldn't want that to be totally open-ended because we wouldn't want them to continue forever waiting for that, but we'll try and think about how to do that.
Thank you.
I was trying to follow that. So you're saying that for I'm totally losing my train of thought. That the mitigation plan has to be finalized before a discharge occurs. That's you're saying that, right? Like that's okay, because that wasn't exactly what I heard you say, but okay.
That's what I was trying to say is what's written in the procedures now. What Catherine was saying is that sometimes there needs to be some flexibility because sometimes that can't happen.
So you're saying that then you're going to write something in there about how you don't have to have a final mitigation plan before a discharge occurs?
I don't know what the answer is.
Okay, well, so let me just be clear.
Sure.
We think it's reasonable that if you have a gap between, when you submit, but, to try to get the final mitigation plan worked out. But I don't think it's okay to allow a discharge to occur before you have finalized your mitigation plan.
Thank you for the workshop today. My name is Kurt Leuenberger. I'm here on behalf of the Santa Clara Valley Water District, and I wanted to say thank you for recognizing that there still are potentials for conflicts between the state determinations of the least environmentally damaging practical alternative and the federal determinations that could result. We do have experience with this working in the San Francisco Bay region, and we wanted to elaborate a little bit about some of the concerns in the alternatives analysis. Primarily, what we're seeing is that water board staff are using it as an opportunity to evaluate alternatives based on potential and historical beneficial uses in the creek system that are being evaluated. This is very different than the federal alternative analysis, which relies on the existing condition at the time of the project going through the application process. And frankly, this affects the constitutional rights of applicants as an environmental baseline is effectively being reset. So we hope you can go ahead and take a look at something like that. Some of the other potentials that we had talked about are the differences in the physical footprint itself. Dealing in our example, the Army Corps was looking at just the concrete channel itself, the waters of the U.S. The water board staff were taking a look at the adjacent habitats, the trees, the riparian habitat adjacent to the trees. This type of analysis and evaluation resulted in a different conclusion on what alternatives should be evaluated. At that point, we were asked to go ahead and evaluate additional alternatives. This increased the time that was needed to go through permitting. You heard me say it before, 15 months was lost simply negotiating back and forth and going through the analysis consistent with the state procedures as they're currently constructed. It's for this reason that you know, our need to provide the critical life safety functions and operations of maintenance can't be compromised without detrimental effects to the community that we serve. And that's why we feel it is a priority that the water agency's comments with respect to exclusion of is a reasonable compromise to exclude the O&M of existing water-dependent facilities from the procedural requirements under Roman numeral 4D. That's definitely something we want to take a look at.
Thank you. Do we have any other yes, there we go, or over here.
Hi, good afternoon. Antonio Alfaro with the Santa Clara Valley Water District. Again, just wanted to point something out that I think hasn't been touched on before. On the long-term management, it's the last page of the final draft that was released back in January, page 41, D3. It provides for long-term management financial assurances by impacting parties. For governmental agencies, it states that in cases where the long-term management entity is a public authority or governmental agency, that entity must provide a plan for the long-term financing of the site. What we're envisioning is that the regional board would have the flexibility to require either endowments, trusts, contractual arrangements with future responsible parties. But for governmental agencies, there would be a separate mechanism that would be a plan. We think that this should be stated more concretely or firmly to allow governmental entities to provide something else other than endowments, which require that the governmental entity set aside significant amounts of funding that then we can't access for other projects.
Can you repeat where exactly you were looking? Sorry, can you bring him back? Okay. It's not the last. Very last page.
Right there. Page 41, D, it's long-term management, and then it's section 3.
Yeah. So if I can, just to bring your attention to the language on financial securities for final compensatory mitigation. You may be familiar with it, but I think it provides more flexibility, and it's, I don't have the right version for the numbering scheme, but it looks right here, financial security.
Yeah.
So, yeah, starting at line 407, that might give you the kind of flexibility you're looking for. We specifically added the last sentence based on a request from local government entities, explaining that, in fact, they cannot, in some cases, put up a bond. They don't have the authority to do so. So we are trying to be flexible in terms of the appropriate type of financial security here in this paragraph. And I don't know if that satisfies your concern or not, but
Well, that's the last mic, so people had better be ready to be done.
And I don't mean to put you on the spot. You certainly take a look at it and get back to us.
Yeah, I'll take a look at it. I think that one of the concerns that we have is that we leave it up with other state agencies to make a decision the highest level of security is going to be an endowment. That's usually where they're trying to head, trying to direct us towards. So we'll take a look at this and see if it, provides us that flexibility.
And I totally understand your concern. We're all constrained by the way that the government allows us to use money and spend money, and so we're not trying to put you in an impossible situation.
Just as a point of reference, our January 21st red line really did address the concerns he's got about the very lines that you're discussing, Phil. So you can take a look at that and see if that's what you intended with the last sentence there.
The evil mic. My name is John Lane with Tanker Materials. I just wanted to clarify one of the requests that we had. I'm not sure if it was totally captured in one of the slides, and this related to climate change assessments in the wetland mitigation plan. And what I wanted to say was that if there is a climate change assessment that's required, which the procedures currently say there is, and if it stays in there, I think it's in everyone's best interest that there be guidelines as to what is and is not included in a climate change assessment. So what I'd say is that last slide that there was the options, I'd say what I wanted was if climate change assessment is required and it remains in the final procedures, that the board direct the water board to then develop guidelines for everyone to utilize what is and is not in a climate change assessment.
Great, thank you for clarifying that. We got two more. But I'm not holding you to it.
Okay.
You buy drinks?
Sorry, I'm only commenting because it came back up. I would urge the board to stay away from climate change. As it was mentioned earlier, that is a rapidly evolving and changing field, and I think it could be quite difficult to keep your staff informed with all of the climate change information as it develops. Thank you.
Thank you. Catherine from LADWP. I'm not sure that we spoke about this, but I wanted to bring to your attention about additional information for complete application, and in particular, the supplemental field data needed from the wet season, and that can really delay and hold up our O&M projects, and so that's a real concern for us.
Okay, I will note that down. It is. I said, well, note that down. It is very problematic to in some areas. You're from Los Angeles. I'm very familiar with that. Things look very different in the wet and dry season. So it's not as easy as saying, oh yeah, that's what we meant.
Yeah, waiting for a wet season may be a long time. So.
Hi, Caitlin with California Coastkeeper. I'm not having anything substantive, just a more procedural clarification question. I know that the intent is that you'll have a menu being brought to the board in another 2 weeks. I may have stepped out of the room, so I apologize if this was already covered, but just curious to know next steps, levels of engagement, the kind of explanation we'll be providing to the board with the different policy options and potential convenings next week.
We're done talking to anybody, damn it. No, we expect, as we indicated, to be talking to people over the next week or so. We're proposing to put these together in terms of the staff proposal of clarifying edits and any areas where we get a more of level of consensus that was they're going to talk about with the maintenance. That's one area. Potentially, there might be others. And then we're going to put together those outstanding policy requests with an attempt at the language for how those would look, and send those out to all of you 10 days before. No. Is that the right date? Okay, it's February 22nd. So he got the right date. I just was 10 days before the board meeting. And if we can get it out earlier, we will. But given our ability to meet everything that I want to do, I'm not sure we'll make it earlier. That's where we are. All right.
Are we going to be able to see your recommendations? I understand that it's going to take you a while to get them all together, but somehow before the 22nd, before they get officially released, or how are we going to know which ones of these changes you've accepted and which direction you're going?
I don't know the answer to that question. We're going to try and be as communicative as we can be with people. We're trying to get back to the people that we've got that made a suggestion and that we're trying to do to see if we captured it. I'm not planning to have another one of these between now and then. And the opportunity for everyone to see everything will be when we release it for the 22nd. I can't guarantee that I will get you every one of the comments that someone else suggested. I just can't do it. Yes.
As one of 5, I'm not real comfortable with that approach because I found today to be extremely useful. And if we don't button up the button-upable issues, okay? So there's a distinction between the policy discussion that we need to have, but for those areas where additional dialogue could provide further clarity, I just don't think that we as a board are in the position to be able to sort through those clarifying issues. And so I understand sort of the time frame that staff wants to move on this, but some additional touch point I think could be very useful, because I don't know that we have the technical ability nor the patience to go through these issues as you all have done today.
Thanks, Dee Dee. And I guess it might help emphasizing what we plan to send out by February 22nd will include at least 2 categories of language proposals for the board. One category, which is what I think you're referring to specifically here, Dee Dee, is the ones that we think are essentially clarifications and may include also things that are identified as essentially non-controversial additions. Those, I think, absolutely our goal is to make sure we have the language perfect. Well, I should never use that for regulations.
Close to.
Close to perfect, yeah, and that everybody has had a chance to weigh in. There will be a whole nother set of options that will be presented to the board that we will be drafting the language on between now and the 22nd. Those are options that at least as of this point, staff is not planning on offering as staff proposals. These are just things that we are hearing from the stakeholders. This would be the language that would accomplish those stakeholder-driven concerns, so that if the board does have an interest in moving the procedures in a direction that the stakeholders are asking, the language would be available for them to do so, and then there would be a discussion, potentially a fairly robust discussion at the board meeting about the pros and cons about each of those. So for those, our goal is to not make sure that everybody agrees on the language, but rather make sure that the language reflects the stakeholders' intent, if that makes sense. So I think we can guarantee that some of those options will be very unappealing to some of the folks here today, and they'll be advocating for and against that language themselves.
Just to clarify that, so let's just say, because I think the issue that we would like to talk about sounds like we may build consensus, and if we were able to do that, is that something that would then end up in the?
It would end up in my.
Is that going to end up in?
As a recommendation, just like the clarification is going to be a recommendation from staff, this would be a recommendation from staff in there as something that came as a that was agreed upon. Doesn't mean the board is going to accept all the staff's recommendations, but it's trying to, how do I say, incentivize folks getting together and talking about it. We're not, that's where that would fit. I do think that Phil left out one category. I think there may be, and this is, I'm going to use the rice example just so that people understand. We are looking at two approaches to deal with the rice issue. One, which would be to say, well, it's in rice, it's not a water of the state, and the other is a example that would, a way to look at that we wouldn't impose the basin plan objectives into inputs into the rice field. We haven't written that second one, but our, at least conceptually, is that we would offer both of those to the board and they could choose. We would be saying, we think that one of these two needs to be chosen because that's where we're trying to go, but it's up to you to decide which way to do that. And so that's like kind of a difference between the first and the second, but it's still an option for the board. And there may be other ones of those. I just can't think any longer.
Thank you. Thank you.
I really appreciate the effort that people have put in today and over the last week and that have committed to put in over the next couple of weeks. It's really helpful for us, and I hope it's helpful for you. And we like you all, and we like to visit with you. So, call us, send us emails. We're going to try and get this buttoned up, but I appreciate the help. Thank you.